There you go. Now you're on. Go ahead, sir.
We're all set?
Okay, we are ready.
Great, okay. I'm going to go ahead and call to order the Code Enforcement Special Magistrate hearings. It's a bit after 9 a.m., Wednesday, April 20th, 2022. My name is Harry Hippler, H-I-P-L-E-R. I'm the assigned Special Magistrate today. The city has two, so I'm going to be hearing these today. What I usually do is go into a opening statement as to how these hearings proceed, and that way everyone has some ground rules. They're general ground rules because we're not in circuit court, we're not in county court. Thank you for being here. If you could please turn off any cell phones to avoid interrupting these proceedings. There are no weapons of any kind permitted in these chambers or anywhere within the facilities. In all issues that come before me, the special magistrate, we ask that everyone show mutual respect for one another by listening quietly to each person speaking, and that everyone refrain from any clapping, heckling, or verbal outbursts in favor or in opposition to a speaker. These are hearings conducted by a city special magistrate, the purpose of which is to give any alleged violators the opportunity to contest the decision of the code enforcement officer, which resulted in the issuance of a civil violation notice. These hearings are what's called quasi-judicial, and as the special magistrate, I'm here and assigned to hear today's cases. I am supposed to act like a judge, but I'm not a judge, so keep that in mind. Since special magistrates have limited jurisdiction and their sole role and jurisdiction is determined whether or not there's a violation that you've been charged with. And to hear the arguments presented by the city, who will go first, and then the respondent, who will next go after that, with reasonable cross-examination. Obviously, these hearings are open to the public and they're recorded. It is required that all persons who testify as to the facts of the case be placed under oath, including the code enforcement officer, which I'll do momentarily. These hearings will also not be conducted in accordance with the formal rules of evidence relating to evidence and witnesses. Any relevant evidence will be admitted if I find it to be competent and reliable, regardless of the existence of any common law or statutory rule to the contrary. All documentary evidence must be submitted for placement in the hearing file. No documentary evidence will be considered unless the alleged violator or code enforcement officer submits a copy for the hearing file. Each party shall have the right to call and examine witnesses, to introduce exhibits, to cross-examine opposing witnesses on any matter relevant to the issues, even though that matter was not covered in the direct examination. Also, to impeach any witness regardless of which party first called him to testify, and to rebut the evidence against him. It is my responsibility to make findings of fact based on the evidence of record. The fact-finding determinations of a special magistrate are limited to whether the alleged violation occurred, and if so, whether the person named in the civil violation notice can be held responsible for that violation. I may also modify the decision or the request or the testimony of the code enforcement officer as to the time for correction contained in the civil violation notice, even if violations have been proven, and even though said time is rebuttably presumed to have been reasonable. I have the authority to assess and order the payment of civil penalties and fines, to issue orders having the force of law, to command whatever steps are necessary to bring a violation into compliance, and to assess administrative costs. In order to make a finding upholding the code enforcement officer's decision, I must find that there is substantial competent evidence that the named violator was responsible for a violation of the relevant section of the code as charged. If I affirm the decision of the code inspector, my order will specify the amount of the civil penalty and fine, the administrative costs of the hearing of not less than $100 if assessed, and the date by which the violation must be corrected to prevent resumption of continuing violation penalties and fines, if any. And that's really what's referred to as a per diem fine if there's a violation that's been proven and shown. An aggrieved party, including the city, may appeal a final order of a special magistrate to the circuit court in Broward County. Such appeal shall not be a hearing de novo, but shall be limited to appellate review of the record created before the special magistrate. An appeal shall be filed within 30 days of the issuance of the order sought to be overturned. If you are found guilty of the civil violation charged, you will be assessed an administrative fee of $100. The city representative will present their case first, as I said, and the alleged violator will present their case thereafter. I will consider the evidence and render a decision after all arguments are heard. At this time, I'll go ahead and we'll have roll call. So if you want to call the people, the staff that are here, that'd be great.
We do it individually.
Okay.
Chief Code Enforcement Officer JOSELINE RAMIREZ, present.
Code Enforcement Officer Eric Richwagon, present.
Code Clerk Mary Carey, present.
Administrative Assistant Nasli, present.
Okay, Harry Hippler, Special Magistrate, present.
And that was Nancy Cardona.
Nasli Cardona, I'm sorry.
Okay, if there are any minutes to be adopted, and I think there are because I had a hearing a couple of months ago, I'll go ahead and adopt those if I already haven't adopted them.
There's none at this time.
None at this time, great. Any adoption of agenda deferrals, additions, modifications?
Yes.
Okay, please.
Chief Code Officer JOSELINE RAMIREZ, I will be dismissing a few cases. That's going to be, and these cases are being dismissed because they reach compliance before the special magistrate hearing date. That's going to be case 5498. That's on page 2 of the agenda, section 7.6. And case 5499, page 2 on the agenda, section 7.7. Case 5516 on page 2, section 7.8 on the agenda. There's one more. That's on page 5, section 9.2, and that's case 5485. This case was for an extension of time. The respondent said that he did not need any more extension, so we'll be postponing this case till further notice.
Okay, so that won't be heard today either?
No.
Great, okay,
And then Officer
Yes.
Richwagon.
please.
Code Officer Richwagon, page 4, item number 8.4, case 6710. At this time, will be dismissed because it has come into compliance.
Great,
And that is all for me.
great, thank you. Okay, all right, at this time, I'm going to swear everyone under oath that's going to testify, so if you could please raise your right hand or a hand, and then if you want to stand, fine. If you don't want to stand or can't stand, that's up to you. Do you solemnly swear or agree to tell the truth, the whole truth, and nothing but the truth? If you could please affirm.
I do.
Great, okay, thank you very much, and we'll just call the cases accordingly. Thank you very much, ladies and gentlemen.
Okay, Mr. Magistrate, we have 2 attorneys
Yes.
present, and we will begin with case 6186, and that's on page 6, section 11.1 on the agenda.
11.1. All right. And if your clients need to sit down, if they testify, that's up to you, counsel, all right?
You repeat the permit, the
6186.
618.
Okay. Are you testifying?
No.
Okay.
But I go first and then you proceed after me.
Okay.
Okay, Chief Code Enforcement Officer Jocelyn Ramirez, case 6186, property owner VIP RE 2503 LLC, site address 2503 John P. Lyons Lane, Pembroke Park, Florida. This matter is here today for our confirmation of fine. A notice of formal hearing to confirm fine was sent by certified mail on April 7, 2022. And it was posted to the property on, a second. On April 7th, 2022. At this time, we're confirming a fine of $23,350.
Okay, there was, just so I understand, if you don't mind, counsel, I'll just ask a few questions and you can ask away if you want to present your case. There was a final order entered on November 17th, 2021, all right? And then you're seeking to impose the fine and the lien today for the amount that you testified to. Is that right? Yeah.
I don't, he has to present why he's here.
Okay, but what's being heard today is a confirmation of fine.
Yep,
Okay,
what's being
great.
heard today is a confirmation
Great,
fine.
okay, go ahead. Counsel, if you could state your name and address,
Sure.
enter an appearance, thank you.
And good morning, General Master. My name is Martin Verster. I'm the attorney for VIPRE.
Your last name again?
Verster, V-E-R-S-T-E-R. I have with me today Lisette Rapiza, and Lisette is the property manager for the company, and we do not come here to contest this particular report. What we are here for is to ask you for abatement, and I would like to offer testimony how we arrived here very briefly.
Okay, please.
Is that right? And before I do that, may I approach
Sure,
to
absolutely.
Officer Ramirez?
Pardon the interruption, I can't hear you.
Yeah.
This is Officer.
Oh, no, everything here needs to, we need to, you just need to, you know,
Yeah, you can,
It's okay. I'm
easier,
presenting,
yeah,
I'm
sure.
presenting Officer Ramirez with no, put it back. With copies of the photographs. The property has been painted in its entirety, and I would like to, and I've presented photographs, and Magistrate
Hippler.
Hippler.
You could just
May
call
I
me
approach you? and give
Special
us a-
magistrate, whatever else you can
Special
call me,
magistrate.
you know, just be kind what you
Right.
call me. Okay, go ahead.
May I approach you
Sure,
and give this to you?
absolutely, sure.
and you said that this was painted as of when?
As of yesterday. I'm sorry.
Yeah,
Hold on a second.
yesterday.
Let me just, before anything else, once we received the notice on April 11th,
Yes,
that was sent to the new company, the new owner, by certified mail,
yes.
I realized that other work that we had done did not complete the job, and I immediately hired a company to complete not just the pressure washing, but the repairs of the front and the painting of the front and all three sides. And so all of the work that needed to be done under the complaint of the code enforcement officer as to this case 6186 has at this point been completed. And if I may, I'd first like to
Sure.
approach you and
Sure,
give you
please.
these pictures.
Yeah.
Did I give you this? I gave you 3 of the same thing.
Yeah.
2 of them back.
That's okay, just be, I don't bite, okay, just be relaxed.
I am
Okay.
very relaxed.
Good, okay, all right. I don't bite yet,
The
okay,
thing is,
all
I
right.
don't know the forum that happened.
That's okay,
Administrative
that's,
here.
that's okay, that's all right,
And
you
I'm
know.
speaking loudly so my court reporter can hear me. And if I may, and then I'm going to offer testimony.
Sure.
But if I may, first direct your attention to this photograph, this picture here.
Yes, got it.
At the bottom, it says before and after. We have a complaint from the code enforcement officer. It started out saying, look, you have graffiti on the back. We initially, and we're talking a year ago, we went to try to paint at that time. And we did that, and within 24 hours thereafter, we had new graffiti. Officer Ramirez even sent us an email saying, hey, new graffiti is all over your building again. So we had to go through a process of getting permission to put a fence there, a protective fence. It took a long time, and then by January 15th, we had a 6-foot fence in place, all permitted, and this property was painted. The back of this building was painted. And I believe it was painted within the time required. What we failed to do, the front of the building we were required to pressure wash and do essentially some repairs, some minor repairs to some cracks and crevices in the building, and touch it up and match. As soon as I received the notice, give me the water from there, please. Yeah. As soon as I received the notice on April 11th, I contacted my painting company and asked them to take a look. They proposed to either do the work as was suggested or just do the whole paint job, and we decided to do the entire paint job. And that's where we are. And I would like to introduce Lisette Rapiza for a moment.
Sure.
And can you just tell the General Magistrate what we have here, what these pictures represent and how we got there?
Hi, good morning. My name is Lisa
I
Rapiza.
think you need to stand
Yes,
closer
please.
to the
A
microphone.
little shorter.
That's okay, that's all right, there you go.
Hi, good morning. My name is Lisa Rapiza. I'm the property manager. I deal with all these management things for years with Joseline. I know her for years and emails, the first time in person. So yes, we try to finish all the requests, painting job and management job in the building. It was a little difficult because for all these years we have this problem for graffiti. Every time we paint, we have graffiti next day, or a week after that, and this is years and years of painting the back. So we decide to do the fence with help of Joseline to see if we have enough space, because
Right.
we have a little space in the back and everything.
Is there a
Finally,
fence now around your?
Yes.
Okay, that was done
Yes.
with a permit and all the,
Yes.
great,
everything.
okay,
Yes.
great.
That's why they take a little longer.
Okay.
Because with the permit, we don't find the contractors right now. It's a little difficult. All the companies don't have people to work.
Right.
But we do it. We try to, do this and finish this. And finally, we try to clean up a little bit the front and fix little patches. But we saw that building and we decided to do the whole thing to be in compliance completely. So I think we're okay now with that. And yeah, finally we finished yesterday. The painters finished the paint in the front and then the sides, and I think everything is done in this case. I
Okay,
think so.
all right, has the city verified that or not? You may-
No,
okay.
because we just got this
Got you,
presented today.
All right.
So I will have to do a reinspection.
right, okay,
I can, since he did show me the photos, that it's
Right,
been
good.
completed as of April 19, 2022, then I can hold that date, but I have to see it for myself. And he did submit a letter requesting an abatement. Now that he is in full compliance,
Right.
according to this photo, we can go ahead and put a motion to abate.
Okay, but,
I just want one or two more
Sure.
questions.
sure.
How do you know Officer Ramirez?
Because always we have this problem with the graffiti and stuff or anything garbage or something in the city. She always contact me by my cell phone, my text or email or something to let me know that we need to fix something and do something in the warehouse.
Do you always respond to her request?
Yes, like almost.
Okay, you don't have to say that. It appears that she does, okay? She's known.
Yeah,
You
we
don't.
have a good communication.
Great, okay, all right.
And
Go
that's
ahead.
all I wanted to submit.
Okay, great. As far as an abatement, it still is a little bit premature because what the city has to do is go onto the property and verify if in fact it's been taken care of and this thing has been complied with, then the abatement's okay. What I'll do is I'm going to pose a couple of, let me hear what the city has to say. I can give you several options, but what's the city's position? And then I'll throw out one, since I try to get these things resolved, if at all possible, so that everybody is reasonably content or not too miserable, whichever one. Okay. All right, so let me hear what the city has to say
One
briefly.
quick thing,
Sure.
John Magistrate. I would like to put those photographs into evidence.
Sure, we'll put it into the file. Okay, I'll get it. Thank you very much. Okay, great. Let's see what the city has to say and see if we can get this thing done with, and so that you may or may not have to come back again. All right, go ahead, sure.
Well, today we're doing a confirmation of fine.
Right.
We will still have to do due process for the motion to abate, so he will have to come back next month.
Okay, are you still pursuing the motion to abate if you get some relief today, or is that really?
My preference would be for Officer Ramirez to do the reinspection.
Got you, okay.
And to have a hearing, because that way I know that whatever happens, if Officer Ramirez says, look, there's still something not right, we get it into compliance, and then you can make a final ruling as opposed to doing a ruling now and then
I know.
go back and forth with the.
Okay, here's the thing, let me, motions to vacate, that issue seems to have come up a couple of times. The Attorney General's office says that, and you're arguing that you didn't get due notice?
I'm sorry, John Master Hitler, you're talking about a different case right now.
Yes,
Oh,
that's a
oh,
different case.
That's a different case.
He has two cases
Okay,
for today.
so this is this case, all right.
Yeah. This one, he's not contesting anything.
Okay, I got you.
He's just asking for a motion to abate, which we're gonna have to, I have to confirm that
Right.
everything's complied with.
Yeah.
And then we'll go to the next hearing. I'm trying to find right now what's the next hearing date so I can let him know.
If I have to go to my daughter's graduation, May 15th through May 20th in Berkeley, if we could avoid those dates, please.
I don't know those dates, but our hearing date is May 18.
Can we avoid that and set it after that?
We can set it for the June hearing.
Okay,
That would
Yeah.
be
fair
super.
enough, we don't want you to miss your daughter's graduation. I think, I'll tell you what, I had a couple of options. I think what first needs to be done is that the city needs to determine whether or not there's compliance. If there is, then they'll determine the date of compliance, the date of violations, come up with a figure, then we can have the abatement. Sometimes the city reduces it by 85 to 90% of what the ultimate fine is. But I think that's the standard protocol to determine compliance. If there are some minor matters that need to be complied, the staff here is excellent. They're not out to get anybody. They're fair. They work with the people. I've done this for years, so they're not out for that type of a scenario. So how about some type of continuance so that that'll give the city an opportunity to go out and see whether your client has complied, all right?
I want to just add one thing, totally very minor. I did tender and pay the $100 administrative fee, both in this case and the case that follows.
Okay, great, all right, that's good to know. But if that, is that acceptable to the city? Because I think we need to find out whether there's compliance. If there is, then the city's position may or may not be, but it may be the date of compliance versus the date of violation. You add up the numbers, then they come up with an abatement figure. Is that acceptable or not?
Yes.
If it's not, tell me. I mean, I'll work
Yes,
things
it
out
is.
with everybody. All right, so why don't we not have a hearing today? Because if I affirm the fine and the lien, that it could be recorded, not that they'll record it, but you don't need that, all right? So in light of your candor in this instance with your client, why don't we do that? I think that's the safest approach. And then it won't get set, if there is if there is compliance, then the abatement hearing will not be until June or whenever you're available.
Excellent.
All right? Okay, so is that, we're gonna go ahead and continue the case.
We'll continue the case for the June.
Yeah,
For the month of
till
June.
June special magistrate hearing.
What is the date, General Magistrate?
It's usually the third
Third Wednesday of the month.
Yeah.
Okay.
But if you need to do a separate order, you'll do it, and no big deal, all right? That way, it's, we follow protocol and standard procedure, and keep in mind, though, that if there's still not compliance, these fines are going to continue to accrue, all right? So I'm not going to stay the fines.
Understood, but if there's still some deficiency, we're going to take care of it right away.
Good, that's good to know.
Thank you,
I
Mr.
assume you
Bester.
will. Great, all right, thank you, sir, okay.
All right. So now we're going to proceed with the following case.
Code Officer Rich Wagon, representing the town of Pembroke Park. This is going to be page 7, item number 12.1, case 6155.
All right.
Counsel, did you want a new file for this, or should we just?
New file.
Excuse me for just 2 seconds.
Here, go ahead, that's all right. Look, in court, we're not in court, but it's really the court reporters that everybody follows. Okay, that's all right.
Can we start from the beginning?
Yes?
Thanks.
Sure. Code Officer Rich Wagon, representing the town of Pembroke Park. Page number 7, item number 12.1, case 6155. Case 6155, property owner identified by VIP RE 2503 LLC. Site address 2503 John P. Lyons Lane, Pembroke Park, Florida 33009. The notice of formal hearing to confirm fine was certified mail on 4/7/2022. It was posted to the property on 4/6/2022. This is to confirm fine in the amount of $15,250, and this does take into account the $100 admin fee. Yes. And that completes it, Mr. Magistrate.
Okay, you're up, go ahead.
Okay. The first thing I would like to do is outline why I'm here. I have before you a motion to quash service, both as to the original complaint and notice of hearing. Well, as to the notice of hearing and the original complaint. And the reason for that being, number one, it was not properly mailed to the owner at the time, Jeanette Verster. It was sent by certified mail, but that certified mail was not received by her, and the posting was legally insufficient. By the terms of statute, I think it's 126, if you do not have a successful mailing with a return receipt, then you need to post it, and there are certain requirements that were not met. And so, if I may offer a little, first I want to have a little bit of testimony, if I may.
Okay, great, go ahead.
Would you come up? Would you state your name
Janet Verster,
and where do you reside?
7220 Southwest 61st Street, Miami 33143.
Did you receive, as to case number 6155, the notice of violation and the notice of hearing for October 20th, 2021?
No.
Did you have an opportunity with me to look up the USPS tracking for that letter?
Yes, that letter's still in transit.
Right. General Magistrate, I attached to my motion.
Okay, could I see a copy of the motion?
Okay. All right. Hold on a second.
Mr. Magistrate, it should be, if you click the link, you should have the motion
At the bottom here?
and the case overview.
Okay, all right, let me. Service. I'm going all the way down here and I just don't find it, but that doesn't mean it's not. Hearing to confirm, find VIP 32503 LLC. Here's the motion to vacate right there. That's okay. 13.1. Is that the one?
Magistrate, it's a motion to quash.
I know, motion to vacate final order. Is this the one, is it 13.1, not 12.1?
No, it's 12.1, case 6155. 13.1, case 6133 is to be heard later.
Would you like to have a hard copy?
Yeah, I'll take a hard copy, but I'm looking case overview.
This is the hard copy.
Yeah, I'll take, well,
that's
all
the
right,
one.
that's the one. All right, let me take a quick look. What's 9425 Sunset Drive?
That is the office of the property manager. That's my office, and that is where Lisette Rapiza, the office manager, works. And that's what's the business address.
Okay, so that's the business address of your client? Right. Okay. Sent to a bunch of addresses.
It was sent to the warehouse and to Jeanette Verster's home.
But the registered agent.
No, that would be incorrect, what you just said.
No, was it sent to the registered agent?
It was not sent to the registered agent.
Mr. Magistrate, yes, it was.
Was, okay, great.
What was, on what date are you talking about?
The hearing to confirm fine?
Yeah,
For the hearing?
here's, I'm looking at the, what's online here, and,
Mr. Magistrate?
Go ahead,
The hearing to
please.
confirm fine was sent to the site property, what was on Sunbiz, and what was on BCPA.
I'm sorry, I thought we were talking about the original notice of hearing and the violation.
Okay, I'm looking at,
Let me clarify
yeah,
that we do.
Martin Verster, that's you.
Right.
Okay, 9425 Sunset, registered agent. I mean, the statute clearly says you can send it to a whole bunch of, like, what the property appraiser's office lists, or the registered agent.
Right. Let me clarify what we are talking about.
Yeah,
As it pertains to the notice of hearing for today, that was received by my office. I'm not contesting receipt of that notice.
Can you please speak into the mic?
Sorry. As it pertains, let me restate, apparently was not audible. As it pertains to the notice of hearing for today, that was duly received, and that was sent, I guess, to the registered agent. I'm not contesting that, but there was no registered agent on September 28th of 2021 when the notice was sent. At that point, the property was still owned by Jeanette Verster, and it had to be sent to her address by certified mail, return receipt requested, and it was not received by her. And I would like to introduce the United States Postal's USPS.com printout that I think I just gave it to you, that shows that it was in fact never delivered.
right, it was never received. Now, Jeanette Verster, 2503 John Lyons Lane, Pembroke Park, 33023, right? Is that where you live, ma'am?
No, that's the warehouse address, and I don't have an office there. No, I don't live there, and I don't have an office there.
Okay, but your name, there's.
I'm the owner.
Okay, but it was sent there.
I was the owner.
I'm looking at the Broward County Property Appraiser's office, I believe here, if I haven't seen it. There, it was also sent, I'm looking at, the ones 8/23/21. It was sent to Miami, 7220 Southwest 61st Street, Miami. And then the mailing address is
Yes.
9425
Magistrate.
Sunset Drive. Yes.
Magistrate, also in reference to the notice of hearing for September 28, 2021, for one of the trackings ending in 9864, which went to 2503 John P. Lyons Lane, upon checking the USPS tracking, it was confirmed that it was delivered and left with an individual on September 30th, 2021 at 12:41 p.m.
That individual, it was not Jeanette Verster. It does not meet the requirements of
Okay,
the statute.
sir, look, what happens in circuit court is one thing. The statute here, and there have been claims made about due process and all that, they've all been rejected. It says that if the property appraiser's office address is followed, or the registered agent, or some, quite frankly, I've seen it where it is some other address that would put the person on notice that that's in rem jurisdiction, all right? Whether somebody receives it or not is irrelevant.
And I'd like to make
Sure.
note, Town Attorney, that's in the code enforcement statute.
Right, exactly.
So it's more specific to this action.
Yes.
What he's talking about is circuit court service requirements.
Yeah.
We notice that the code enforcement statute specifically applied to code enforcement action.
All right.
And we have proof and evidence, you said
Yeah, and just one, it's okay, I'll let you have your says, you can tell, I'm flexible and that, maybe too flexible, but the fact that somebody doesn't sign the green card is irrelevant, as long as there's service. I mean, there's U.S. Supreme Court, I've researched this in other areas where the government can send stuff, and even if they don't get it for tax assessments, that may be good service. We're not there. I'm just drawing an analogy. I like to conceptualize sometimes. I don't have to do that here today. The Florida 162 was followed based on what the code officer has said, and that's really that's what I've seen thus far, all right? Whether she received it or not is completely irrelevant. Go ahead.
All right, you're making conclusions based upon incomplete evidence.
Okay, well, tell me more. Go ahead. All right,
Exactly.
From thus far, from what I've seen, I don't see anything that would, support your position, but go ahead.
Let me
May I
just,
have the complete spelling of opposing counsel, please?
Anderson, first name Melissa, M-E-L-I-S-S-A, last name Anderson, A-N-D-E-R-S-O-N.
Pardon the interruption.
No, that's okay. That's all right.
perfect. I just want to finish up. Can you, did you receive a copy of the order that was dated October 20th and it was also sent by certified mail?
No.
And is that also one of the certified mail receipts that is shown on the USPS.com,
Still in transit?
still in transit? I don't know if I did this, but the USPS.com printout, I asked to have that also made part of the file into evidence.
Yeah, let me also say, and this is from a example that I recently had happen to me, where I filed my tax return, I sent it via overnight, or not every 3 days. The U.S. Postal Service, even though I know the IRS received my tax return, the USPS statement, when I go online, says it's still in transit. So that, quite frankly, look, the Postal Service has been underfunded. They're great. I want them to work out. But the evidence thus far strongly suggests that there has been good service here based on this statute. I'm just saying that just because the Postal Service says it's in transit, that's, okay. I'm just giving an example, all right?
You're making, for all intents and purposes, you're reaching factual conclusions without me having presented all the
I'm giving you an
evidence.
opportunity. I'm playing devil's advocate. Go ahead. All right.
All right. Officer Rich Wagon, is that?
Yes.
First of all, did you receive return receipts for the mailings that were mailed on September 29th and the subsequent October 23rd mailing representing the original notice of violation and hearing notice and the mailing of the order of the magistrate?
The original NOV that was issued on 8/23/2021 was sent out by regular mail. It was not returned to the town, which means it was sent. As for the final order, on October 22nd, 2021, it was sent out to all proper addresses. And again, certified mail for 2503 John P. Lyons Lane was received by someone there. Give me one moment. For tracking number ending in 7293, it was delivered and left with an individual on October 25th, 2021 at 1:15 p.m.
Do you know who that individual was? The last one.
No, but it was left there. Because
So you
according,
don't know if that's a manager for Jeanette Verster at the time?
I will repeat this again. Florida state statute says that we have to send it to
Please do not
BCPA.
interrupt when I'm presenting a case. When I'm presenting my evidence, allow me to do that evidence without leading this witness.
Okay, I'll tell you what, let him go ahead and answer, okay, officer, then we'll, go ahead.
Mr. Magistrate, if I can just, state this for Florida Statute 162.12, Section C, and I'm going to read it in full. Okay. Notice of publication or posting may run concurrently with or may follow an attempt or attempts to provide notice by hand delivery or by mail as required under subsection 1. 3. Evidence as an attempt has been made to hand deliver or mail notice as provided in subsection 1, together with proof of publication or posting as provided in subsection 2, shall be sufficient to show that the notice requirements of this part have been met, without regard to whether or not the alleged violator actually received such notice. I end
Good.
my statement, Mr. Magistrate.
Can you let him finish, sir? Go ahead. Good, great, go
Are
ahead.
you, may I proceed, or are you still?
Yes, Mr. Magistrate, I ended my comments on this section. I just wanted to
Okay.
bring it forth.
And
Then-
incident, I'll just ask, was it also posted on the property?
The NOV was sent out regular mail. It was never received back. As for the notice of hearing, the notice of hearing was sent out to all addresses, Sunbiz, BCPA, and it was posted to the property. As for when it was posted to the property for the NOH, we have picture confirmation that on 10/1/2021, the notice of hearing was posted on that property.
And how about the order that was entered and the prior prior
I have
times?
so for the NOV that was initially issued on 8/23/2021, I have a scanned copy with the date on it of the mail that was sent out.
Mr. Magistrate, can we wait for the town attorney to get back? I didn't notice that she was not in the room.
Yeah, we can do that, but I think she left for other purposes, so we can go.
Did she mention that?
No, she didn't, so we'll go and if she wanted to have it.
Well, she
held up,
did say that she was going to be here present. That's why.
Want to go track her down?
Yes,
then?
I will.
Okay.
You want me to wait, in other words?
Yeah, wait like 30 seconds or however long, so.
I hate this thing that's leaning like this because everything wants to fall out. What? No, don't need, doesn't mean, no. It doesn't matter.
The coded officer was looking for you, but you're back, so. Yeah, brief.
Yes.
Yeah, she was they wanted you present, that's fine.
All right, may I proceed?
Second, now we're all back. Yes, thank you for your courtesy, counsel, and the city attorney, that's okay.
All right. Then if I may,
Sure.
Rich, what?
Would you like his card?
No, that's okay. I'm sorry. When I have these glasses on, I can't see it. All right. Officer Bitchwagon, I'd like to show you, or I'm sorry. Do you have in your files certified mail receipts ending at 9871 and the other one 7309?
Is this in reference to notice of hearing to
Yes.
confirm fine? Okay.
Yes.
Is this for the original notice of hearing?
Yes?
Okay.
And I'd like you to focus on the one for the original notice of hearing.
Okay, understood. Give me one moment. Just to read it back to you. So
Please, if I may, do you have that receipt?
I'm trying to confirm it with you. Last ending in 9871 and ending in 9864 to confirm?
No, I'm only focusing on the 9871. Do you have that one?
Yes, I do.
All right. Can you, on this certified mail, on the certified mail receipt, it has an address, a name and address of Jeanette Verster. Is that correct?
Yes, that's correct.
Is that also the way it appeared on the envelope?
Yes.
All right. Would you please read the full address that appears there?
Yes. Line 1, Jeanette Verster. If you need me to spell it, I'll spell it.
No, spelling not necessary.
Okay. Line 2, 7220 Southwest 61st Street. Third line, Miami, comma, Florida 33143. Line 4, dot, NOH number 6155.
Is the NOH 6155, is that part of the address as it is listed on the property appraiser's website?
No, but it identifies the notice of hearing. Also, if there was an error with the mailing, it would have been sent back to Town Hall. None of these certified mail receipts were sent back in error from the post office.
You are saying it would have been sent back to Town Hall?
Yes.
And how do you know then?
Because we've received returns in the past for incorrect mailing. Mr. Magistrate,
Go ahead.
Mr. Magistrate, I do want to put in, although he's stating 9871, it was also sent to 9864, certified mail, September 28, 2021. This one was delivered, and again, left with an individual there on September 30th, 2021 at 12:41 p.m. And this notice of hearing was posted to the property, 2503 John P. Lyons Lane, on 10/1/2021, and we do have photographic evidence of that.
Right. Now, with respect to this return receipt, the certified mail receipt, I'd like to make that part of the record in this case
Sure.
as evidence.
Yeah, I'm going to make your whole motion to vacate
Okay.
part of the record. And, yeah,
Right.
let me, I'm looking at, you're not contesting the notice of hearing, proper notice for today, I
I'm
assume.
not.
Okay, and you're contesting the events in October of 2021.
That's correct.
Okay.
Let me be very clear.
Yeah.
I'm contesting the service.
Right.
I am asking you,
Yeah.
as magistrate, to quash the service,
Yeah,
and I would like to present a little bit more evidence.
sure.
All right.
Okay, but before you do that, I'm looking at certified mail copies sent to Jeanette Verster, 7220 Southwest 61st Street, Miami, with the zip code. There's also Jeanette Verster, 2503 John P. Lyons Lane, Pembroke Park, 33009. I'm looking at, this is in October 22, which is part of the record and the like. Then I'm looking at September 2021. I believe it's to the same addresses. They're certified mail sent by the city. They're actually, you know, I'm just looking in overwhelming amounts of certified mail items sent to these addresses. So you can continue to go on if you want, but go ahead. Sure. Go ahead.
Officer Richwagen, you just mentioned a letter that was sent on August 23rd, 2021. Is that correct?
Correct.
Is it your contention that that letter served as a proper notice in this case?
Objection. Special Magistrate, this has been asked and answered extensively. He's now harassing the witness. He's got his answer. Service is in conformance with the statute. Please, let's move on. If
Yeah,
he wants
you
to
know,
contest it, let
No,
him
look,
appeal.
Sir, counsel, I've let you go because it's my nature to let things be informal. But I've read to you what is already part of the record.
Then may I proffer?
Unless you have, if you want to proffer quickly, but we have a bunch of people waiting.
Right.
And I need to move on, all right?
I
mean,
understand.
Okay, so
But
let's
here-
go.
Then let
okay?
me proffer.
Go ahead, proffer.
I mean, tell me that, then please make a ruling that you want me to stop, and the only thing you will permit me to do is make the proffer.
Okay, make the do whatever
Right.
you want, but
Let
I'm not gonna have this hearing go on for hours, okay?
The proffer is
Let's
as
go.
follows.
Sure.
The August, give me 1 second, where's my Bible? The August 23rd letter that was referred to was not a substitute for the required service of process. Number 2, the posting affidavit. And I want to be very specific.
Sure.
And I wanted to ask the code enforcement officer, is there an affidavit of service? And let me be more specific than that. I have reviewed an affidavit of service that shows that it was posted on the property. The statute, 162.12, says as follows, because the representation was not complete. It says as follows: if certified mail receipts are not delivered and haven't been recovered, then you can post. And the posting is required to be in by two methods, both of which are required. Number 1, a posting on the property, and number 2, a posting at City Hall. I have reviewed the affidavit of service. It shows that there was a posting on the property. I asked, prior to this hearing, during the past week, I asked Officer Joseline Ramirez to send me a complete copy of her files on all the evidence presented. It did not include an affidavit as required by the statute showing that it was posted on the property. So I am contending that, number 1, there was a failure to make the proper mailing because the address is not identical to the way it appears on the property appraiser's website. Number 2, the statute being very specific. If one fails, you must do this, and you must then do the posting by double posting, which was not done by the code enforcement officer. At least there's no affidavit as required by the statute. That is my proffer. And so I'm suggesting that service was not correct, not legal. One final thing that I want to add is, in case 6168, I have no argument, argument about service or anything like it, but something similar happened in that case. And on September 23rd, 2001, I filed a request for rehearing and reconsideration in the 6186 case because mailing was improper in that case. And in that particular case, the general magistrate granted the motion to set aside the service. And it was filed, and Officer Ramirez, I'm certain, remembers this, and I would like to make this.
That's relevancy?
It is relevancy as a precedent.
No, it's not relevant as it's a totally different set of circumstances. We don't know what you're talking about. I don't know what the grounds were for having the rehearing. This is, Your Honor,
Okay.
as to his proffer, he hasn't shown that there was he has failed to show that there was lack of service by mailing.
Right.
So it was proper service. This town's actions were proper. The service was proper.
Right. I would like
Properly
to offer
before you
into
here today.
evidence
Okay,
the.
you can put it in and I'll consider it for its worth, okay?
Thank you, may I approach?
Yeah, sure, but I will consider for its worth, okay?
That's it?
Yeah. Okay, I've listened to the argument and convinced, based on the evidence and the questions that I posed, the testimony that's been presented, that there's been adequate service with 162.12 and any other requirements. There was certified mail that was sent. The property appraiser's office address was followed. Actually, there are like 3 addresses that it was sent to. And also, the property manager was also served as well, which would put them on notice. So I'm going to go ahead and deny your motion to vacate. All right?
Just the last statement you made is factually unsupported by the evidence. The property manager, Lisette Rapiza, was not served. And as the court had, as Your Honor, as you as magistrate heard earlier, there has been a constant communication over 5 years with my property manager and the code enforcement officer.
Whatever the evidence said, someone signed a receipt, a green card. Is that correct? All right,
That's the evidence.
Excuse me.
Yes, you're right.
Okay. And that was for the September and October notices. So, including the statutory requirements. So, based on that, looking at the statute, especially 162.12, 1A, certified mail, at the option of the local government, return receipt requested to the address listed in the tax collector's office for tax notices or to the address listed in the county property appraiser's database of the local government may also provide an additional notice to any other address it may find for the property owner. Notices may be provided by certified mail to the registered agent of the corporation. Okay.
There was no corporation at the time.
Well, either way, that's my rulings. I'm denying the motion to vacate. All right. Thank you very much.
Can you state the ruling on the record so we know?
We're going to call the next case. I've made my ruling and I've stated it on the record.
Mr. Magistrate, can you please confirm the fine?
Yeah. How much is the fine?
Allow me one moment. The fines are $15,250 with a credit of $100 that was paid for the administrative fee.
Okay. I'm going to go ahead and confirm the fine for $15,250, and that it includes the $100 credit.
Thank you, General
Thank you.
Magistrate.
Good luck to everyone. Next.
Mr. Vester, if you hold a minute, they'll hand you a copy of the lien.
Thank you. I'll wait outside.
Okay.
Sure. Oh, yeah, thank you. Let me do this.
Mr. Magistrate, just let me know when you're ready, okay?
Yeah, I'm ready. Thank you.
Next case is on page 5, section 9.1. Case 5364. Chief Code Officer Joselin Ramirez, case 5364. Property owner Trinity Broadcasting of Florida, tenant Juan C. Torres Ortiz. Site address 3300 Pembroke Road, Pembroke Park, Florida, lot 449. This matter is here today for an extension of time. A notice of formal hearing to extend time was sent out by certified mail on April 4th, 2022, and posted to the property on April 4th, 2022. At this time, I would like to extend this case for an additional 30 days at a per diem fine of $100 per day and a $100 admin fee.
Yes.
Good afternoon, Your Honor. Juan Blandino on
It's
behalf.
good morning, but it may feel like afternoon.
Good morning, Your Honor.
To everyone watching as well.
It was a little long, but we're
Really?
here nonetheless. Thank you, Your Honor. Juan Blandino on behalf of Trinity Broadcasting of Florida.
Yes.
We're here on a motion for extension of time. The court's ruling was on February 16th. It granted 45 days to
Right.
comply with.
I remember it was a landlord-tenant matter. You're an RV park. I'm familiar with your company, Quality Company, and you haven't gotten the tenant out yet.
Yes, Your Honor. Well, the writ of possession was actually issued by the judge, probably, I think, right around April 3rd, which is right around the time of compliance. But
Right.
what happens in practice is that the sheriff's office, they're a little bit behind because of
Yes,
things, because of the
they are.
pandemic. Needless to say, we finally got the possession of the property. It's just a matter of time for the property manager to schedule maintenance to get out there. And I believe, I spoke with her yesterday, the code compliance violation should be remedied as of today, the earliest, likely tomorrow. So I just wanted to make clear with Officer Ramirez's request to the court whether it would be $100 from 30 days from now.
Yeah.
Okay, perfect. Yeah, I'm fine with that.
Yeah, no, there's no fine. You've moved for an extension of time, so I think there's $100 cost assessment.
Right, there's an admin fee of $100
Right.
that will have to be paid within 30 days.
Right.
And the $100 per diem will start after 30 days.
All right, awesome. Thank you. I'm
Great.
in agreement, Your Honor.
Great,
When-
okay, good luck. And
I just have a quick question. When
Yes.
you say remedy as of today, what does that mean?
The property manager, Renee, scheduled with her maintenance to remove the violation that was assessed. I think it was a structure abutting the recreational vehicle. That will be removed, so everything should be in compliance.
Okay, because you need a permit to do that. A
The-
permit to remove a structure?
Well, the writ of possession is granted, so it'll remove I believe it's just like a abutment, but if
Right, it's an addition to the RV home that they installed without a permit. So they have to obtain a permit to remove it. Demolition permit.
Okay, Your Honor, then Officer Ramirez, do you know how long that takes?
Typically, within 30 days, you can get a demolition permit and get your final inspections. So, I mean,
Give them longer just in case you have a problem with that, because they're gonna be compliant and they're moving. I mean, it's up to you.
I could do 45 days.
Okay.
Given the fact that they had to evict this
Yes.
individual.
Okay. All right, so how about 45 days?
From today?
Yes.
All right, awesome. Thank you so much.
Great. Okay, just get it taken care of and, so it goes away. All right, let me go ahead, so,
Thank you, Your Honor.
yeah.
All right, and if you hold a moment, they'll give you a copy of the amended final order.
And what was the $100 a day after 45 days?
Yes.
Okay. ready, whenever. Oh,
Do you need Okay, next case is on page 6, section 10.2. That's case 4447.
Good morning.
Good morning. I'm going to present the case first, and then you'll go ahead and speak after I'm done presenting the case, okay?
It's just because he doesn't speak English, so
Okay.
I'll try to translate to him.
All right, I appreciate it. Thank you.
Okay.
All right. Chief Code Enforcement Officer Joseline Ramirez, case 4447, property owner Michelle Donace, site address 65 West Lake Drive, Pembroke Park, Florida. This matter is here today for to abate the fine. A notice of hearing to abate the fine was sent out by certified mail on March 23rd, 2022, and posted to the property on April 5th, 2022. The fine accrued to $9,200, and it is the town's motion to abate this fine to 10% of the per diem fine, which would be a total of $1,058.50. That includes the $100 administration fee and the recording fee of $48.50.
okay, what, this is 10.1, 10 point, what number?
That was section 10.2 on page 6,
Thank
case
you.
4447.
I reviewed these yesterday. Let me hear what you have to say, please.
Do you have a letter here?
Yeah, okay. I can pull it up here, as long as you sent it to the town, but I'll take it, yes. Okay, go ahead, what's your position? Go ahead.
Qu'est-ce que tu as fait?
Ce qu'on a fait, on a demandé à notre ami qui est arrivé là-bas de s'occuper de ça.
First, they didn't know that they need a permit to have the air conditioner, to remove it. They have a notice, and they asked a friend of them to take care of it because they went back to Montreal because of the COVID.
Après, ben, quand on est arrivé, on est venu ici pour s'occuper de ça.
When they back here, they
En
take care of it and
février.
take a permit in February.
Okay, yes, I am aware of that.
But there were violations, it got remedied, and that me? No. No. It's somebody. Okay, the town wants to reduce it to $1,058, which is a 90% reduction. Okay, anything else that your client or the gentleman has to say, Mr. Donace? Right?
Yeah.
Anything else?
Does Mr. Donaze understand that we're reducing the fine?
Est-ce que tu comprends que là, ils réduisent les frais?
Oui, c'est ça, ils réduisent les frais. Okay.
Yeah.
Okay, thank you so much.
We're reducing it from 9,200. That was the total amount.
Ils te réduisent de 9 222 $.
And now we're reducing it to $1,058.50.
Maintenant, le montant, c'est 1058,22.
That includes the $100 administration fee
Ça inclut le $100 d'administration de frais.
and $48.50 that was for the recording of the lien.
Ça, c'est inclus à 48,22 pour le lien.
Okay?
Okay, that needs to be paid within 30 days. Okay, if it's not paid within 30 days, then it will revert back to $9,200.
Si tu ne le payes pas dans les 30 jours, ça va revenir à 9 000 ton amende.
Okay. Est-ce qu'on peut payer tout de suite?
he asked if he can pay now.
Yeah.
He may leave a check at the building department,
So that it's there.
yes,
to file
with
check
Lucy
building. With Lucy
or Jeffrey.
or Jeffrey, that's it.
Okay, perfect. Thank you.
We-
Okay.
Not that, correct.
So,
Okay.
based on the testimony, I'm going to abate it to $1,058 to include everything, including the administrative fee and $48.50. And it's to be paid within 30 days. If it isn't paid within 30 days, then it'll revert back to the $9,200. You're going to pay it today, that's it, you're done with it, okay?
Okay, thank you.
Thank you,
Thank
good
you
luck
so
to
much.
you. Okay, sure.
I
If
will
he
give
hangs
you a-
on, yeah.
I'm sorry.
Go ahead, go ahead, go ahead.
I will give you a copy if you hold on a second, please.
Yeah, you can call the next case.
Okay. Mr. Magistrate,
Yes.
Code Officer Richwagon, representing the town of Pembroke Park. Page number 5. Give me 1 second. Item number 8.9, case number 6747.
Good morning.
Hold on 1 second, sir. So I'm going to present the case. Once I'm done presenting it, then you can speak, okay?
I just said good morning.
Oh, no, I know, I'm just making sure. All right. Mr. Magistrate, case number 6747, property owner identified by Parker Lone Pine West LLC, site address 3030 West Hollandale Beach Boulevard, Pembroke Park, Florida, 33009, unit number 360, Lone Pine. A notice of violation was issued on 2/23/2022. Certified, 1 second. Certified regular mail on 2/23/2022. Notice of formal hearing was issued on 3/23/2022. And posted to property on 4/6/2022. The violation is for work started without permits for a shed in reference to Florida Building Code, BCPA 105.1. My recommendation is 30 days with a fine of $50 for the violation.
Okay, and this is what, what number again? Not the case number.
I'm sorry, page 5, and it'll be item number 8.9.
All right, sir, go ahead.
Good morning. My name is Urbano Cuba. I'm a new resident for Broward because Broward's, I come to the city and tell me Broward is different than Dade County. I don't know why, because we go by the state of Florida, all the law. But I was a resident on Miami-Dade County, okay? I decided to sell my house, decided to move my shed that I have, that I owned, that I got permit for it. It's certified by the state of Florida, Dade County and Broward at that time that I had the shed. I moved to the trailer, and I had a shed that is really, it was been there for 30 years, 20 to 30 years, and I decided to actually take it apart and just replace mine with the shed that it was there, assistant. I thought there's a law by grandpa, you know, that you're replacing one thing to another as long as you meet the code of what it is, you know, the standard of it. But I guess I was wrong. So I did it. I didn't get a permit, but I have evidence here that from the trailer, the same day that I was there, that I did it, I got it approved from them.
Sure, I'll take a look, yeah. And you say it, when you go back there, you need to, back to the microphone, okay? Cuba.
Same day that I talked to the association, the trailers.
Okay.
You know, and I told them my situation, that I was replacing the shed. It was okay with them.
All right, it
The-
was okay with the,
With them to
code,
do,
the
to
park.
replace.
Right, okay.
Then I got citation because I didn't do it with a permit. I showed you, I came in, I don't know why they're charging me another $50 if I already paid $350, but plus the violation of it. Or 300 and, I don't know how much it was. My dispute is that I try to present the shed. I did the application. I don't know if that you could show the application that I was putting, it was a used shed, but they were considering like it was new. I don't understand a state of Florida that if you own a shed and you buy it 5-10 years from it, you cannot take it to one house to another. Imagine even in Broward, if I live in the corner and then I want to pass it I move to another 2 or 3 street, I cannot replace my shed because it's not standard of the code from last year, 170 miles per hour, and my shed says 150. So they don't take it because my shed says 150 miles an hour. I don't understand. So everybody here has to throw away their shed when they move out, when they buy a house, and buy a new shed, because you cannot transfer, you cannot transport one shed to another property because of the standard of what it is to the code. I talked to Superior Shed, to their company. I tried to figure it out another way that they could do it to stand it to the 170 miles. They told me there isn't any right now. But every county in Florida, Broward, and everything having the same issues that I'm having, because you're going by the station, the code, state code, by 221, but they should honor you, but you got a permit from the time from 150 miles.
Did you transfer the shed to your new property?
Yes.
And the city's position is that the shed is not code compliant?
Yet 170 miles per hour.
Okay, well, what you're gonna need to do is, based on what I'm hearing, is that if he could take the shed and put it on your property, what did you use the shed for incidentally?
Storage of my tools.
Okay. If you can do that, and I'm not saying you can or you can't, if you can do that, you're gonna need to be code compliant with the town's code provisions, which is that you're gonna need to get a permit,
I have a permit.
well,
Sorry.
has it been approved by the city that they?
No, because of the standard, because they're going the statute of 2021. And my shed has I have the plans. I found the plans. I call State Florida. They send me the plans of the shed. I provide them. I want to provide them the shed, the plans. How when I purchased it at the time of 2015 or 2016. Okay, and what I wanted to do is, to give me the right, to actually stay the shed there. But you tell me, I asked them, please tell me a way that I could do it. They told me they cannot do anything. And that's my problem. And I don't understand.
Okay.
If I come to be a resident here, this Broward or whatever it is, and I'm trying to work things out to get my shed to code, and they're not giving me the tools, or I talk to engineers, and engineers telling me, I could give you a list of engineers that I've called, send them email, send in my plans, and they say they never heard that before.
Yeah, okay, here's the thing. The city's position, so I understand it, is that he needs to get a permit or that he just can't have the shed there.
Yes, he's required to get a permit. He has come into the building department, spoke with the chief building official, Mr. Miguel Nunez, also spoke with Lucy. They explained everything to him. So the violation remains open for code enforcement because there was no permit pulled and because it hasn't been finished and hasn't been closed. So that's why we're here today.
All right, so if the shed goes through with this, and incidentally, sir, just because your mobile home approves this doesn't mean the city is gonna approve it, obviously. If they approve it, maybe that's one good step for you, I don't know. But, so, if he comes in and he becomes code compliant with that shed, he makes sure that it follows the city's code and the law, then it would be okay, but he has to go through the process with the city.
Yes,
No.
Mr. Magistrate.
Okay, so what's the problem
The
with that?
problem is, they don't have an answer.
Mr. Magistrate,
Engineer doesn't have an
if I
answer.
may interject.
Go ahead, yeah.
Okay, his situation is a bit complicated, as he mentioned. So it's not that the building department hasn't given them an answer. It's just, it's very difficult. He will have to go, the insignia has been compromised when he removed it from his old home.
Right,
And it's transferring it to the new home.
right.
So now he needs to certify that insignia. So in order to do that, he has to go back to the manufacturer. And that is very complicated. And he doesn't know if the manufacturer will even do that.
I spoke with them, excuse me to interrupt. I talked to Raquel, I have a phone number. I talked to Mercy about it. The owner, like someone representative or big boss there, I talked to them. They told me that they're having the same kind of problem with every other city, Sunrise and every other city, regarding the shed, because everybody that now, unfortunately, we all change, we're getting older, we're getting younger, there's younger people going to code enforcement.
I'm not getting older.
Me either. But, they're concentrating on the state of Florida, what it is, but they're not actually, they're trying to superior engineer them, the shed, trying to get to the city to explain to them that the statute, what it says, you should honor something that was already purchased 4 years ago. Imagine everybody here, a superior shed, you're talking about 10, 20, 50,000 shed. And everybody wants to, it's a mobile shed. And it's not doing it for a living. And you want to move it from A to B, then you have to be on the standard 170. So everybody that has spent, imagine last year spent $10,000 on a shed. What I should do? Throw it away and buy me another one?
I know, but the thing is that what you're talking about is what might be called reciprocity, where each local government has to okay what the prior local government okays, and that's just not how it works. Each local government does have, for better or for worse, it does have independence to determine that. So how long do you think it'll take for the town to maybe come up with a conclusion about that?
The town building department has come into a conclusion. He has to follow, unfortunately, that's how the Florida Building Code 2020 is written. He has to follow those rules.
Okay.
I mean,
Gotcha.
his argument would be great at the Florida Board of Appeals.
Right.
That's where he, because that's where they would honor the shed that he removed from his old home. But we don't have any say. The town doesn't have any say.
Got you.
The
Okay.
building department has to follow the Florida Building Code 2020.
So can his shed be upgraded, perhaps?
They don't have an answer.
Well, why?
He can buy a new one, yes. But that will cost him
So
money.
that means 20 people, 20,000 decides to live in Broward every day, and they bring their shed, they have to throw it away? Because at that time, I have the tag. It was approved from Broward, Miami, and I think up it is.
Here's the part. As a special magistrate, I don't have jurisdiction to deviate from what the code provisions say. That's something that you would have to argue at another forum, whether it's the commission or the in Tallahassee or wherever it is. So I can only, if the town says that you have to upgrade it and you can't upgrade it, then you're gonna have to upgrade it. I don't have
I
the
understand.
jurisdiction to do that.
And I understand what you're saying.
I'm not
but-
unsympathetic, and
But
I don't think
I am a
any-
resident,
Yeah.
and I'm not a lawyer, I'm not an engineer. I'm just a resident, and I'm talking me through everybody in the
Right.
whole Broward.
Right.
I'm representing me, like being a resident, and all Broward. If there is a law, and they're bringing it restriction of 170 mile, they should have, I think, they should have a resolution to do for the residents, because we pay taxes, we pay everything, giving us the way of the tools, how to do it to get it to code, okay? Not the way she says, buy another one. That's not,
Yeah, I understand that, but they don't have, unless the
but
ordinance.
how they're
is
forcing something
changed.
if they don't have the tool to work with it.
Okay, well, that's what the law is now, so I can't deviate from what the ordinance
So
says.
I suggest, what do you think that I should do?
Well-
Throw it away too?
I don't, sir. I'm a special magistrate, and that's it. I have limited jurisdiction. My opinion may be one thing. I have to follow the law. The law here says you have to follow what the town requires here.
But-
You have to find a way to upgrade it. If you can't, then you're gonna have to buy a new one. I guess that's the way it is. I don't know what else to say.
Mr. Cuba, your options would be, yes, to buy a new one because a new one would be up to code. Or if you want to pursue this further, you can go to the Board of Appeals, which is who writes the Florida Building Code. If you want them to change it, that's who you would go to. But that is complicated. But those are the options that we can give you.
I see it, unfortunately, I never had this kind of situation with any other city. I'm sorry to say that. This is a really small city, and I don't want to get to details regarding certain things that I think is right or wrong. I moved to a trailer, kind of retired, wanted to retire to get out of all this headache, and I just decided to put a shed. And suddenly, I get enforced so many things on a private property, because that's a private property. That's not an open property. And you're saying that you have the right to be there and do certain things. But with state of Florida, what's going on, there's another property that everybody's trailer, they have to take it. They give them $200, and the city suddenly walks away and say there's nothing they can
Mr.
do.
Cuba, let's redirect this to your
That-
case, please. We're talking about your case today.
But I'm talking about my case and the case of every other citizen here
Okay,
that has,
I can't do anything about that, so what I'm gonna do is this, you were going with 30 days, how about if I'm gonna go with like maybe 60 days?
The-
Give him more
the-
time to think about what he wants to do.
the problem, sorry.
But I'm gonna have to enforce this, I have no other alternative.
Okay, I'm sorry. You know how it is with Colby? Even with buying a shed, it's gonna take me a year to get it. You tell me, now I talked to Superior,
Okay, listen to
shed,
me. I cannot remedy everybody's problems, you know, I'm not.
I thought we were here for you to discuss my problem and to help me out.
I'm here to determine whether there's a violation, all right? If you know, the Board of Appeals, as the code officer really wisely suggests for you to do, otherwise I have to enforce. So what I'm gonna do is,
So
I'm
then-
gonna give you 60 days in which to comply, and you're gonna just need to make some hard choices, that's all. I mean, we are talking about a shed. We're not talking
But
about
you're
a
talking,
home.
but we're talking about $5,000 shed.
Okay.
It's
I
not
understand that.
$300 or, you know, air conditioning wall that I could replace it.
Okay.
It's something, for me, it is important. Maybe
Okay.
for other people.
I can't do anything about it, all right? I just can't.
Okay, so,
I cannot do anything about it. I don't have a magic wand that says this is the way it is, all right? So.
but the law, there has to be,
I
you
don't
know.
know what it is, okay?
But
You've been
that's-
given options, okay? What I'm gonna do is, based on the testimony and the evidence of the code compliance officer, I'm gonna find there's substantial competent evidence to support the city's position. You'll be given 60 days in which to comply, or $50 a day thereafter, and you're gonna have to find a remedy to that. What people should do is not assume things before you move. You need to do due diligence. You did whatever you could, that's fine. You're stuck with the facts the way they are. I can't do anything about it. So I'm gonna go ahead, 60 days or $50 a day thereafter. That'll give you more time, if that's acceptable to the city. And
Mr. Magistrate, I have no problem with 60 days to help him out.
yeah, see if and if you come up with a conclusion and you need more time, as long as it's not a year, because a year is just way too much, talk to the code officer. The staff here is excellent. They try to work with people. You've gotten some ideas. It's become a public forum here to express grievances, all right, about a lot of things. That's not what these proceedings are, okay? So with all due respect, so I don't have power.
No, I'm not saying you should
No,
have
I
a
wish
power.
I did, but I don't.
The thing is that, unfortunately, you know, we work in a city that we have, like you say, everybody should get along. And whoever breaks the law, I understand.
Yeah, okay.
You know, I break the law, I'm fine, I'm paying for it, but suddenly they don't have an answer.
But it's not just this city. Apparently, many of the cities are doing the same thing, so it's not just Pembroke Park, all right? So I need to move on to another
Okay.
case.
Let me ask you something. Can I say something?
15 seconds, let's go. Okay, go ahead.
You know,
I
thank
can't-
you.
I can't
You know,
spend-
I understand.
I just can't, okay, really?
Yeah, you're talking about a shed, it doesn't matter.
Okay.
For me, it is.
Okay,
But
good
thank
luck
you,
to you,
thank
sir.
you. No, good, I need the luck. I
Okay,
need the luck.
okay, right,
I'm just
okay.
saying, if we're talking back and someone else, let me ask you something.
Sir,
18
please.
seconds. Now, I'm discussing this. I get a fine, I get 30 days. I sell my shed.
60 days.
And 60 days, I sell my shed. And 3 months, there's a lawyer suing the city and all that, and they win the case. They're gonna refund me the money?
Sir, next case, I don't know. Okay, good luck to you, all right?
Please hold on a second, I will give you the copy of the,
Yeah, let me
Final
sign
order.
off here.
I will give you a copy.
Oh, do you want this back? Okay, could we make a copy of this, and then that would be, no, we'll give you a copy back, just a second, okay? There you go. If you could just make, oh, no, for the file, give the gentleman back, yeah. Thank you.
That one is for her.
Mr. Magistrate, Code Officer Rich Wagon, representing the town of Pembroke Park. Page 4, it's going to be it's going to be item number 8.3.
Great.
And it'll be case 6670.
Leslie, make a copy so I could put it in this file. Okay.
Mr. Magistrate, case 6670, owner Pembroke Gardens LTD, site address 3841 Southwest 52nd Avenue, Pembroke Park, Florida 33009, and this is for unit number 101. A notice of violation was issued on 1/31/2022. It was posted to the property on 1/31/2022. Notice of formal hearing was issued on 3/22/2022, certified regular mail on 3/23/2022. The violations for this specific unit are as followed. There were several spots in the ceiling of apartment 101 that have water damage indicating a roof leak. There was a black substance growing throughout the unit, on the walls and throughout the AC. The bathroom tub was in a state of disrepair. The ventilation above the stove was not in proper working condition, and because it was sparking, I believe it posed a health and safety threat.
Okay.
That concludes it for the violations. The recommendation I would give would be 30 days to come into compliance with a fine of $50 for the violations.
Okay, yes, ma'am.
Mr. Magistrate, Mr. Magistrate, I do apologize for the fine. Instead of $50, I would like to move it to $100.
Okay. All right, ma'am, your name?
Good morning, my name is Catalina Montano, and
Why don't you put the microphone down a little, that way everyone, great, thank you.
my name is Catalina Montano, and I'm the property manager for Pembroke Gardens. We already started making all the repairs. We're only missing, we had an issue with the tenant upstairs. We couldn't go inside her unit for a few days. We were able to go yesterday into her unit, so we are fixing on the roof leak that it was coming from the bathtub. And that was fixed. The only thing we're missing now is the other bathtub from the other bathroom.
Okay,
So
so
we're doing that today.
30 days enough time, it should be?
Yeah, that's what we're
Okay,
doing.
all right, great, thank you. Based on the testimony in the evidence and compliance officer, I'm going to find that there's substantial competent evidence to support the city's position. You have 30 days in which to comply, or $100 per day thereafter.
Okay.
Thank you, good luck. You'll get a copy of the order now. Thank you.
Next case is on page 2, section 7.5. That's case 5417. Chief Code Officer Jocelyn Ramirez, case 5417. Property owner Parker Lone Pine West LLC, tenant Medellin Camejo. Site address 119 Lone Pine Lane, Pembroke Park, Florida. A notice of violation was sent out by regular mail on November 2nd, 2020. It was sent out, a notice of formal hearing with a copy of the notice of violation was sent out by certified mail on March 25th, 2022, and posted to the property on April 5th, 2022. The violations were for installation of an AC mini split without a permit, windows and awnings without a permit, and vinyl siding without a permit. There has been no permit obtained as of March 24th, 2022, and I have not been in contact with anybody from the property. So my recommendation, since it's been ongoing since 2020, October 2020, is to give them 30 days to comply, if not $100 per diem with a $100 admin fee.
Your name and your position.
My name is Gisela Nunes. Okay.
How do you relate to the case?
Well, I bought the property like 3 years ago.
Oh, you're the owner then, right?
Yes. Yes. I don't know why my name doesn't appear. I don't know.
Well, did you registered with the mobile home park?
Mm-hmm.
That's the name that they gave me. So unless
They haven't changed it. Okay. So, okay, I'm new in this situation. I don't know. I think you passed by, Jocelyn?
Mhm.
Mm-hmm. And the guy who sold me the unit,
Mhm.
He said that he will hire, some, I don't know, guy, who had a permit, something, because he works for someone. And he said, he said, fine. I went to the office. I got the paper they gave us. I gave it to him. And he told me he already did it. And he continued. So that's what I thought. It was resolved. So now I received the letter. Now that 20. One, it came in the mail from Madeline Cameo. I didn't know. So I threw away. So that one they put in my window. Let me see what's going on. So that's why I'm here. So in my situation, I would like to know what can I do to fix errors that I made, like the split.
you still have to obtain the permit, so you have to go to the building department.
Mm-hmm.
Since it's a AC
Mm-hmm.
and other things that you have to get a contractor to do it.
Yeah. What about the windows? I haven't done anything. The property was like that.
Okay, so then
So what is the
if
meaning?
you're saying that they were like that,
Mm-hmm.
that means someone changed it. And if that's the case,
Okay.
what you can do is we have an Amnesty Program where there's property owners,
Mm-hmm.
who purchase mobile homes with violations already on it. So the Amnesty helps you get an engineer to fix the violations.
Oh my God. So that means that those window that had the trailer doesn't belong, that's not a.
That means that
doesn't have
somebody
any-
changed the windows. Those are not mobile home windows.
So I bought it like that.
And then also the vinyl siding.
So how do I get those,
You would go to the building department and obtain the permit, or to apply for if you're the mobile home owners, as you say, you would need a copy of your title, a bill, a utility bill, and your driver's license to match that address, 119 Lone Pine Lane.
So permit for the AC with the contractor and with the
Window, awnings, and vinyl siding.
and the awnings too. Oh my gosh, I can't believe it.
Yeah, what was your name? Was it Madeline?
No, she says she's
No,
Gisela Nunez.
Yeah.
Okay.
So I have to verify with the park. Technically, the park is the property owner.
Right.
So
okay.
they give me the names of their tenants, and that's the name that they gave me.
Okay.
Now, if she's there's something that we can hold off on the order, and I can verify.
Yeah, you might want to, just a suggestion, you go with a number of names, because this seems to
Right.
be one of those situations where, there was
Right.
a sale, but the title wasn't changed, and that.
Exactly.
So
It could be one of those
I
situations.
have the title and the lease.
I know, but okay, you're right. Okay, anyway.
Yeah.
What
I didn't know better. I should have bring it, I don't know.
No, it's
So-
okay. We've run into this issue many times.
Okay.
Sometimes the property manager says that the current tenant did not
Doesn't change.
register or something happened, so we just need to verify that.
Okay.
Okay, so I'll hold off on the order, but I will make by ruling that, that based on the testimony evidence of compliance officer, there's substantial competent evidence to support the city's position, and the owner will get 30 days in which to comply or $100 a day, but we might have to change the caption, Parker Lone Pine West LLC dash mark Madeline Camejo, Camejo dash mark, it may be your name as well, so, you may or may not have good title without, these mobile homes are not, their title needs to be transferred properly.
No, I already have, and they have copy and everything. It
Of
was
the title?
Everything. They haven't done their job.
Okay,
Because they're
do
supposed
you
to.
have the
right?
title, do you have the title?
My home, in my house.
Okay, then you need, I think, to provide it to the code officer
Yes.
to make sure you're the
And
owner.
at least two, I have at least two that I
Okay,
made. they
well, the
made.
lease I'm not that concerned about because that could have my name on there, it doesn't
No,
matter.
no, but I mean, I got both.
I know.
They asked me to change
It's the title that,
and
and it should show up in their public records as to, because mobile homes are they're like cars or like vehicles or personal property. Okay, you want me to hold off on signing it, or I can sign it and then we can
Yeah,
just put
you
in
can sign it and then we'll change the name
yellow
on top.
flag? Okay, that'll be fine, just make sure you do that.
Ms. Nunes, here's my contact. Please call me the minute you apply to that and you get approved. Yeah.
But I have to change first. I wait for to change you have to change name here, to change the name?
No, you don't have to wait.
No? I can go up today over there? Okay. Now, do you think that I can, with 30 days, I can make it?
Well, this has been open since 2020, October 2020.
Yeah, but that's what I
Almost
thought the
2
guy-
years, so
That's what I thought the guy had did. Yeah, I know.
it's
my
something you
mistake
have to
because I
keep on
didn't know-
top of.
I didn't know better.
If you need more time,
Mhm.
file for a request before the
Makes
30 days is up, okay?
Yeah, makes sense. Makes
Okay,
sense.
you know,
If I
all
want to
right.
have more time, I mean,
Then do it beforehand, because if you do it after, you might be a waiver. So do it beforehand, okay?
yeah, I want to
But
be on
just
time.
get on this, okay?
Thank you very
It's
much, okay?
Good
I'm
luck,
sorry.
all right. Once you yellow tab this and until we get the right name on there. Right, exactly. You.
Excuse me, Jocelyn, have I to give her a copy or?
Yeah, just keep the copy. We'll send it certified mail.
Okay.
Actually, Nasli, give her a copy for now, and then we'll just change it when we mail it.
Okay, I will leave you.
Yeah, because if you don't have my name on it, I cannot have to do anything, right? Okay.
Not necessarily.
Not necessary?
You're saying you're the owner of 119?
Mm-hmm.
So it's the violation is on the property.
Gotcha.
Next case is on page 6, section 10.6, case 60001.
Good morning.
Chief Code Officer Jocelyn Ramirez, case 60001. Property owner Art Defco LLC, site address 3181 West Hallandale Beach Boulevard, Pembroke Park, Florida. This matter is here today for an abatement. A notice to abate the fine was sent out certified mail March 23rd, 2022, and posted to the property April 5th, 2022. The total amount that is requested to be abated is $15,600. It's the town's motion to reduce this fine by 15%. So that would be a total of $2,425, and that includes the $100 admin fee.
Yes, sir. What is your name, please?
My name is Douglas Driver.
A
Meridian
little
Commercial.
bit louder.
My name is Douglas Driver with Meridian Commercial. We
Great.
represent the owner. We're
Okay,
commercial
so
real
you
estate
don't have to
consultants.
hurt your back when you move that up a little bit. You know.
I appreciate that. Thank
That's
you.
okay.
And good morning.
Go ahead. Talk to me.
Yeah, that's 90% would be better, but we'll take whatever you guys are willing to.
Okay, so 2425. Okay, that's what you owe. $2,425. It's an 85% decrease. Sometimes it's 85. Sometimes it's 90%. Sometimes it's 80%. Sometimes it's 50%. I've seen that. So 85% is not bad. So, okay, is that
Agreed.
acceptable?
It's acceptable.
Okay, great. Okay, and payable within 30 days, or it reverts back to the original amount. You know that.
Understood.
Okay.
Is 30 days sufficient?
Yeah, we should be able to pay that in 30 days. Not a problem.
Okay, I'll go ahead and grant the abatement. Total sum would be within 30 days. Reduction to five. Days. Okay. Fair enough. It's cities don't have to do this. You're fortunate to live in a city that does it. Okay.
Understood. Thank you.
Thank you very much. Take care.
Please hold on a second. I will give you a copy, okay?
Right. There you go. Thank you.
Next case is on page 6, section 10.5, case 5143. Morning. Okay, Chief Code Officer Jocelyn Ramirez, case 5143, property owner Ron B. Smith, site address 3911 Southwest 52nd Avenue, Pembroke Park, Florida. This matter is here today for an abatement. A notice of hearing to abate fine was sent out certified mail March 23rd, 22, and posted to the property on April 5th, 22. The total amount to be abated is $3,150. My recommendation is to reduce it by 10%, and that would be a total of $405. That includes the $100 administration fee.
Can you repeat the total again?
$405.
That would be my total.
It'll be that's the town's motion to abate the $3,150 amount to $405.
Okay. Can we make it a record day and make it 100% abatement? I'm
You
just
gotta
joking.
ask
I'm
the
fine with that.
magistrate.
I'm fine with it.
My sinus is one. I'll put to 3150. Do you want me to do that? It'll be $405.
So my total will be $405.
Okay, when can you pay it?
Is
say the
30
minimum
days?
is 30 days.
30 days
Maximum is 30
sufficient?
days. Yeah, that's cool.
Okay.
Okay.
Okay, I'm gonna go ahead and grant the abatement. The 400.
Do you have water? Okay. you
Oh,
have
no,
water.
I have it, sure. there was an 850 here by accident. Don't worry, you don't need to do it over. I just went ahead and initialed it. So it's 405.
Okay.
Thank you. Thank you. Sure. Good luck, sir. Take care. Sure.
Next case is on page 6, and no, actually, hold on here. Yeah, it's actually on page 6, section 10.3, and that's case 4523.
Good morning, ladies.
Good
How are
morning.
you?
Morning.
I'm just here as a translator. My
Great.
name is Liz.
You could put the mic down.
I'm here as a translator. I'm here to help
Great.
her out.
Okay,
And what's your name?
Liz.
Liz, and your last name?
Korf, K-O-R-F.
All right, thank you. Chief Code Officer Jocelyn Ramirez, case 4523, property owner Parker Lone Pine West LLC, tenant Adriana Magales, site address 3030 West Hallandale Beach Boulevard. I'm sorry, 343 Lone Pine Lane, Pembroke Park, Florida. This matter is here to abate a fine. A notice of hearing to abate fine was sent out certified mail March 25th, 22, and posted to the property on April 5th, 2022. The total amount requested to be abated is $6,950. Is the town's motion to reduce this the per diem fine by 10%, and it's a total of $785. That includes the $100 administration fee.
Go ahead.
Good morning. My name is Adriana Magallanes. I need she translate me. I don't understand all in English. Okay? Okay.
Okay, why should it not be decreased to $785?
Why shouldn't it be decreased?
Yeah.
Hang on a second. Do you want to translate to her what I said, or did she understand what I said?
She understood that because she explained to me. Here's the bottom line.
Okay.
She happens to work where I work, part-time. And
Yo no tengo el dinero. No sé cuánto tengo que pagar ahora.
$700.
Okay. Los $700 al trabajar 4 horas por día, yo no puedo pagar la renta del tráiler, pagar los $700, excepto que me los den a pagar porque no tengo.
Can you please speak into the mic?
I'm here also to confirm that she does work only 4 hours a day, 4 to 5 days a week, because she works in where I work presently, and for her $700 is a lot. Either she says that she can't even afford that, and that either unless they let her pay it out in payments, it's fine, but she cannot. She doesn't have that kind of money,
Okay,
and she could barely pay her what she's living now, and that's a lot for her.
Okay, what I'm looking at, how severe were the violations here? Let me take a quick look here. Repairs and installations. Work shall proceed. Repairs. Were they substantial violations? A little bit. This was signed by the Code Enforcement Board.
I don't know what I'll be honest with you, because I work with her, she asked me to come and translate and help her out, because I know her already for a couple of years. I don't know exactly what her violation, I've been asking her, but I was at work yesterday, I couldn't talk to her over the phone. But I don't even know what the violation was, I'll be honest with you, so I'm here.
The
standing.
violations was for mobile home addition converted from screen room to living space with acrylic windows.
Okay.
So she did go ahead and pull the permit and,
She did pull the permit?
yeah. Yeah, we can only do an abatement if she complied, so she has complied with her. Yeah.
Ah, tú arreglaste la situación.
No, no, sí. Ok, el tema es de los $700, no, yo los puedo pagar, pero no puedo pagar en un mes todo, porque trabajo 4 horas y no tengo todo ese dinero porque no me alcanza. Me quedan $200 al mes para la comida y pagar esto. Y estoy enferma. Tengo ataques de pánico y ansiedad.
So she really can't afford it. She took care of the situation. This is her first time living in this kind of mobile home. I don't know how long she's lived there, but it is true. She's trying to work hard. It's just really hard for her.
Well,
I know.
Is there, does she own the mobile home?
Tú lo rentas, ¿verdad?
No, es my
Oh, es tuyo.
Es mío, es
It's
mío.
hers.
Okay.
Pero a partir
Right,
de la...
she owns a mobile home. Okay, do you have a car? Do you drive a car?
¿Tú manejas un carro?
Yo manejo un carro, sí.
Yes, she does.
Okay, all right.
She basically, I know, she basically lives paycheck to
I
paycheck.
understand that. I understand. Do you have any children?
No.
No.
Or is she, some of these are, do you have a significant other? Do you live with anybody? No, you live by yourself?
She does not, no.
Okay. What's your monthly maintenance?
¿Cuál es tu mantenimiento mensual ahí?
795 con...
795 and change.
That's for paying the mobile home park.
Es el mobile home.
La renta de la tierra.
The rent of the space, of the, yes.
Okay.
Más la luz, más...
Plus her electricity.
No, I understand that, but if she only works 4 hours a day, it sounds like, there's maybe a bit more income that she's earning.
Now I have sick, I no work more time.
I'll tell you what it is. She does have a permanent 4-hour work at the synagogue where she works she does cleaning, and they only call her, there's nothing permanent. They only call her as she's needed.
Right.
But permanently, she has 4 hours a day, and then she's on call. That's basically, it's on call. It's an on-call thing for her.
Which synagogue? I'm just curious.
Here in Hollywood.
Okay, all right. I don't know, this financial circumstances, the city's really being gracious based on this. Usually I don't do this. What I'm going to do, the city wants to impose $785. She's going to have to find a way to come up with a lump sum to get rid of
Could you give her
this
more time? Maybe, I don't know, maybe 90 days for her she could split it?
What I'm going to do is I'm taking what she's saying under oath to be accurate. There's nothing here to show that she's not being truthful. I just have to.
I'll tell you, I work for the synagogue myself as a preschool teacher.
Yeah.
It's called the Hallandale here on 1295 East Hallandale Beach Boulevard.
Okay. Yeah.
And the rabbi there gives her 4 hours a day. I know for a fact I am stating this as truth.
Right.
And they call her on call.
Yeah. Okay.
So because I am a preschool teacher there, I've known her since I've been there for the last 2 years, and it happens to be truth.
Okay. No. Okay. Does she
So
have medical
I'm testifying for her that
Does
it is
she have
true, and
medical
she's the
insurance?
cleaning lady there.
I
and-
understand. Does she have medical insurance?
What?
Medical insurance. Does she have
No,
medical?
¿tú tienes seguro médico?
Ahora no, ahora no.
She does not at the moment.
Medicaid? Does she have
Tiene
Medicaid?
no.
No. Okay, I'm going to go with a flat $500. Okay, but she's going to need to pay all of it. 30 days. Is that acceptable?
¿Te lo van a reducir a $500?
Mr. Magistrate, I think 90 days would be
Okay.
better.
90 days for
Okay,
$500.
te lo van a reducir a
Okay.
500 y te dan 3 meses para pagarlo.
Okay.
Okay, that's better, she says.
Okay,
Te dan
I mean,
3
I'm-
meses,
look.
3 meses que son 90 días y te lo van a reducir a $500.
Okay.
Okay, okay.
Okay, all right, so $500 within 90 days, or it goes back to
Que si te dan los 3 meses para
$6,950.
pagarlo, y si pasa un día, te vuelve a los $6,000 otra vez. Tienes hasta 3 meses para pagarlo. Si no lo pagas de aquí a 3 meses, te vuelve el monto a $6,000.
Oh, okay,
¿Ok?
okay, okay.
All right? Okay, try to help a little bit. The city is too.
I'll remind her.
Okay,
Can
whatever.
you give her something to
Yeah,
how she pay for
I'm gonna
that?
do that right now, okay.
Me duele la cabeza.
No, se te lo van a deducir. Sí, pero igual.
Nestle, do you have the order for Mr. Vester? That was VIP? You gave it to Lizette?
Yes, I gave it to her.
There you go.
Okay, give me one moment.
And el building department. No, ya no es allá. Tú entras por la puerta principal y vas al building department. She'll do it once a month.
6155.
Good luck to you, ma'am, and be well, whatever. Be well. Are you back for more action, Counselor?
No, I had to leave to go to the warehouse, and then I.
Okay,
forgot,
I
so
was,
I'm here for the order, but.
okay, that's
Yeah, we
okay,
are
they'll
working
get
on
it for you, right? It's okay.
Next case is on page 2, section 7.10. That's case 6567. Chief Code Officer Jocelyn Ramirez, case 6567, property owner 1730 PR LLC, site address 1730 Southwest 30th Avenue, Pembroke, Florida. A notice of violation was sent out by regular mail on December 10, 21, and a notice of formal hearing with a copy of the notice of violation was sent out by certified mail on March 23, 22, and posted to the property on April 5, 2022. The violations were for a prohibited banner sign and a prohibited abandoned sign. At this time, both signs have not been removed. My recommendation is to give them 5 days to remove these signs, if not a $250 per diem with a $100 admin fee.
Yes, ma'am.
Please state your name for the record and how you relate to the case.
My name is Lila Hidra.
Yeah, closer to the microphone, please, okay.
Hello. My name is Lila Hidra. I represent Mr. Shlomo Malul. He's very sick. He couldn't come here today. So I will try to do my best.
Are you the property manager? What is your title?
I'm not, I'm just, he asked me to come instead of him because he couldn't come here today.
Are you a relative, a friend?
Friend.
Friend.
Friend of the family.
Knows you're here?
What?
Does he know you're here?
Yeah, he sent
Does he
me
want
here.
you here?
Yeah, he sent me
you
here.
here.
He asked
Okay.
me as a favor to
All
come.
right. All right. 5 days to remove these signs, right?
Yes.
That's the bottom line.
Yes.
Okay.
Okay?
The sign is, yeah. Second, I wrote to myself. Okay. The tenant applying for the right permit.
You need to talk louder, please. Okay. Yeah.
The tenant.
Did you understand what I presented?
I know what he told me to answer about each thing.
Okay, because what I presented in the case,
Yeah.
I didn't speak about a tenant. I spoke about there's a banner sign
Yeah.
and an abandoned sign on the property.
Okay.
Those banner signs are still currently on the property. They have to be removed.
Okay.
Do you know if they've been removed?
First of all, we're talking about, there is 3 cases here.
Right, so that's why I'm asking you, did you understand when I presented this particular case? Because there's 3 cases.
Okay, so which case we're talking about?
The ones
69?
about the banner.
6909?
6567.
6567. Yeah, about that, he told me that the tenant applied for the right permit.
No, that it has nothing to do about that. It has to do about signs. He obtained a permit for a sign?
That's what I know.
Okay.
about that.
Okay.
What he asked me is to get an extension for 30 days. The tenants applied for most of the things here. We are trying to comply with the.
Well, for the
violation.
signs, I am not going to give 30 days to remove a sign.
Oh no, not to
There's
remove the
there's
sign.
been ample of time. That's what we're talking
No,
about
not
here.
about to remove the sign for.
So you have 5 days from the date of today within 5 days you have to remove them, and you got to call me when they're removed so I can do a reinspection.
Okay.
Okay.
Right? 5 days
To
to
remove the
remove the signs, get them out of there, or it's going to be $150 a day. Okay?
Okay.
Okay, based on the testimony and evidence, there's substantial competent evidence to support the city's position. The authorized representative of the owner who's here with his knowledge and direction to be here has 5 days in which to remove the signs, take them off the property, or $150 per day thereafter. And there's, of course, a $100 cost assessment as well.
Okay.
All right?
Okay.
Thank you. There you go.
What was the per diem fine?
Oh, you said 150?
250.
250.
Yeah.
I'm sorry.
No, it's okay.
I didn't. If you don't remove them within 5 days, it's $250 per day. All right?
Okay.
Really should be a very easy thing to do.
Yeah.
Thank you. Good luck to you, ma'am.
Well, she has two other cases.
Okay.
Yeah. The next case is on page 2, and it's section 7.11. That's case 6771. Okay. Chief Code Officer Jocelyn Ramirez, case 6771, property owner 1730 PRLLC, site address 1730 Southwest 30th Avenue, Pembroke Park, Florida. A notice of violation was given by regular mail on March 2nd, 22. A notice of formal hearing with a copy of the notice of violation was sent out by certified mail March 23rd, 22, and posted to the property on April 5th, 22. The violations were for pave and restripe parking lot without a permit, portable trailer on premises. Portable trailers are prohibited. Storing items in warehouse unit without a business tax receipt. Tenant has to obtain a business tax receipt for business use. And another prohibited banner sign. At this current time, none of these violations have been complied with. So my recommendation is, since section 21-19 is a repeat violation, I will assess a fine of, recommend to assess a fine of $500 per day from the day of the notice of violation, which was March 2nd, 22. Which it gave the respondent 14 days to comply from the date of the notice of violation. And then as for the section 5-105, 5-17, 15-17, 28-346, A and F, I am giving them 15 days from the date of the formal hearing, if not a $250 per diem, and a $100 admin fee.
Yes, ma'am. Your position. State your name for the record and why you're here and who you're here for.
My name is Lila Hidra. I'm representing Mr. Shlomo Malul.
I know he's not here, but he's authorized you to be here. He wants you to be here. He can't be here, but he told you to be here for him, right?
Yeah.
Yes?
Yes.
Okay, great. Go ahead. Yes, thank you.
Okay. At the first two, he asked what it's regard for, what to fix. Repaired and installation shall be made. And so about those things, we don't understand what it's regard for.
Ma'am, I just presented the case and I said everything. Okay. I'll repeat it again.
Can I take a pen, please, to write to him?
We're going to give you an order, okay? All right?
Thank you.
Go ahead. I think you were clear about, if you want to repeat, that's up
No,
to
I
you.
repeat it again.
Okay, all right.
I'm sorry. Just for the record, are you fluent in English or do you speak another
Not
language?
100%, but
Do you speak another language?
Hebrew.
Hebrew. Okay. I don't know that. All right. So what he needs to obtain is a permit for the paving and restriping they did on the parking lot. So he needs a permit for that. Portable trailers are prohibited, so they can't have containers in the warehouses. Those have to be removed, or there could be wheels attached to it. But at this time, the tenant that you have there does not have a business license. So the property should not be in any type of use because they don't have a certificate of use or a business license.
The
So they need.
container was already removed.
Okay.
It's not there anymore.
All right. So this is what I need to know. When things are in compliance, when things are happening, you have to call me so I can go out there at the property and do a reinspection. Okay. So now that you told me that, after this meeting, I can go ahead and do a reinspection that the trailers or the containers were moved. And then your tenant put another banner sign. So the banner says fume on it, and so that's a repeat violation because first there was banner signs with for lease. You had banners that said for lease, and now another banner is added on top of that. So now this is a repeat violation, and based on the previous case, which was 6567, since it's a repeat, now the per diem is $500, and it starts from the date of that notice of violation, which was March 2nd, 22. This is a lot of information. I know that it's a lot to process. So if you want, after the meeting, you can call me and we can set up an appointment and I can break all of this down for you. But it is a lot. Okay?
Thank you. He's saying that he's going to correct the sign with a permit.
If they're going to correct a sign with a permit, that means they're probably going to get a permanent sign. So we need more details, information about that.
Okay, is that it? Yeah.
Yeah.
Okay, the order that's in reference to the $500 per day going back to March 2nd. Okay, so in this order, it just says code of sections 21-19 within blank days of the date of notice of violation. How about just comply with the tenant section 2119 issued on. I'm going to strike within that part. You see what I'm saying? Or
Can you repeat it one more time?
yeah, let me show you, and then you'll take a look. And then what's the others? The more vanilla ones, 250
Yeah, 250 for, and
How many
I'm recommending
days?
15 days.
within 15 days. 50. Take a look here so we get this right now, if you'd be so kind enough that way. That way, we'll get you the paperwork in a second. See, it's really, the 500 relates back to March 2nd. So if I put within some days, so how? That's okay.
Yeah, 14 days.
Within 14 days of the date of the notice of violation.
Yeah.
Which is March 2nd. Okay, within 14, got you. All right, I didn't get the, so that means there's already a bunch owed. So that will be from March 16th, time at $500 per day until there's compliance. Gotcha. All right. All right, based on the testimony of the compliance officer, there's substantial competent evidence to support the city's position. Since this is a repeat violation, 21-19, within 5 years previous, within 14 days of the date of the notice of violation, which was issued on March 2nd, 2022, it's $500 per day. For the others, 5-105, 5-17, 15-17, 28-346, A and F in parentheses, within 15 days of the date of the formal hearing held on April 20th, 2022, that would be $250 per day. Right? And you'll just show it to the owner, and you'll take it from there. Okay?
Okay, she still has one more case.
Oh, another. God. A lot is happening on Passover.
Mm-hmm. Yeah.
Okay, the next case is on page 3, and that's on section 7.16, case 6909. Chief Code Officer Jocelyn Ramirez, case 6909, property owner 1730 PRLLC, site address 1730 Southwest 30th Avenue, Pembroke Park, Florida. A notice of violation was sent out by certified mail, and a notice of formal hearing was sent out by certified mail on April 6, 22, and posted to the property on April 7, 22. Violations were for unlicensed business activity continues on property 1730 Southwest 30th Avenue. Property is responsible for multiple commercial trucks unloading materials onto 1730 Southwest 30th Avenue and obstructing public right-of-way. The tenant, again, has to obtain a business tax license and certificate of use. And at this time, there has been no business tax or certificate of use. They have to discontinue any use of town's public right-of-way for unloading or loading purposes. And this is a repeat violation because the business continues to operate without a license. So my recommendation is for sections 15-17, 15-175, 15-176, and 15-177, that the date of the notice of violation, April 6, 22, a per diem of $500 be assessed. And that was within 5 days.
Okay, so within 5 days of the date of notice of violation?
Yes.
Which, okay, within 5 days, all right.
And then sections 22-85A, 28-215, 5 days, if not a per diem of $250 with a $100 admin fee.
50 per day, and how many days again was that?
5.
5 days, all right. You mentioned 28-85A and 28-215?
Mm-hmm.
Okay, great. Okay, yes, ma'am.
Okay, about the parking, we corrected that already, and we're parking only in the lot. About the container, was corrected already, was container for unload merchandise for a few hours and not anymore.
Mary, can you please show the photos for case 6909? Right there, they're using the road. They cannot use the road to unload. That can't happen again. They were blocking traffic. There was 3 trucks out there blocking traffic. And that's why it's important for them to obtain their business license. That way they have a business plan and they have a section where they're supposed to unload the materials onto the warehouse. But it cannot happen on the road.
Got it? Okay, based on the testimony of the code compliance officer, enter a final order within 5 days of the date of notice of violation issued on April 6, 2022, 15-17, 15-175, 15-176, 15-177, $500 per day because it's a repeat violation. As to sections 28-85A in parenthesis, 28-215, to be within 5 days of the date of the formal hearing, which is today, or $250 a day thereafter. Okay, it's a lot of stuff here that happened today. You need to go back to your to the owner. And again, for this is the 3rd case, right?
Mm-hmm.
And did we get your name down for this case? Got it for the prior
Lila
to?
Hidra.
Same person. So your name again?
I'm still Lila Hidra.
Okay, you haven't changed, and
No.
you're here with the owner's consent authorization directive for him, right?
Yeah.
Okay, thank you. I just need to ask that. Thank you. All right, good
And
luck.
here's my card if you need to call me, okay?
Thank you very much.
Please hold on a second. I will give you the copy of your cases.
After this case, can we take a quick recess?
Absolutely, absolutely. I know it's not enough action for everybody here, so. Okay.
Next case is on page 6, section 10.1. That's case 4405.
Good morning.
Good morning.
Your name, please, both of you, if you, yeah. Well, we'll take your name and then we'll get to the office.
My name is Nancy Romero, and I'm the property manager for Pembroke Business Park.
And the gentleman next to you.
I'm David Wagoda, manager of Pembroke Business Park.
Great, okay, thank you. Now, sure.
Chief Code Officer Jocelyn Ramirez, case 4405, property owner Pembroke Park Warehouses Holding, site address 3121 Southwest Street, Pembroke Park, Florida, unit 675. This matter is here today for abatement of the fine. A notice of hearing to abate the fine was sent out by certified mail March 25th, 22, and posted to the property on April 5th, 2022. The fine to be abated is a total of $50,800. It is the town's recommendation to abate the per diem fine to 15%, which is $7,605. The total will be $7,705. That includes the $100 admin fee.
Okay, abatement suggestion recommended 7705. Okay, this was a dumpster matter or not? Okay, talk to, what were the violations?
We were correcting the floor, and unfortunately, they damaged the wall, so it was done without a permit.
The wall, right, okay, yes.
Yeah, as soon as we stopped the work, we got our permits, we filed for an application, we did everything to code. It was closed on February of 2021. I was not aware at the time that we had a lien against the property. So once I found out, I started calling the town of Pembroke. I wrote a letter back in October 2021. Unfortunately, I did not hear back until last month that they were ready to do an abatement of the fine.
Okay.
I would like you guys to consider that we did complete the job. We met back in 2021 to reduce even more than 15%, or 85%, I should say.
Okay, and this is walls, were there any like extraordinary circumstances about getting the walls taken care of? Anybody injured on the property or anything? Nothing like that? Okay.
No, nothing like that.
All right, and that took some time. You weren't aware, but you know,
To be honest with you, we thought we had complied once we had received final inspection and everything was cured. But apparently it wasn't because there was a lien against the property.
Right. You're willing to reduce it, you know, to 15%, which isn't bad. So what do you think is fair? I mean, don't tell me zero, you know, that's not
No,
gonna happen.
obviously. I would say either 5 or 10%. I do have a letter, sir, that I can show you that it was sent in October of 2021, asking for assistance on this.
Okay, what I'm gonna do, I mean, town can reduce it 0, the town can reduce it to 90%, 85%, with a net of 15, 10%, that type of, I'm gonna go, any problem with me going somewhere between 10 and 15%, or do you?
I'm gonna refer to you.
Okay,
It's
all
your
right.
decision.
I'm the one that, okay, oh
Yeah.
dear, okay, well, what I'm gonna do is, I'll give you a little bit more of a break. I like to do that because I think mitigations or abatements are extremely important. These things take time. People do mess up. You know, the $50,800, while a city has the authority to assess that under Florida case law and the like, it shouldn't happen, and it's not gonna happen. So I'm gonna go with go $6,500. Okay, I'm gonna reduce it to 65. Actually is a bit more than 10, but less than 15. How long do you need to pay?
Thank you very much.
How long do you
30
need?
days is fine.
30 days, all right, I'm gonna reduce it to 6,500.
Thank you.
That's okay. Order signed. Okay, yeah, 6,500, I feel comfortable with that. You should too, under the circumstances, so good luck to you. If you don't pay that, which you will, I feel confident, it reverts back to 50,800. So you know what you need to do. Or I've got it here, I've signed it with the amounts, a little bit more of a break. Go from there. Okay, thank you. Thank you for your courtesy and respect. There you go.
Please hold on a second. I will give you a copy of the abate.
No, 6,500. ¿Sí? Okay. Okay.
All right, Mr. Magistrate,
We're all
ready to
set,
continue.
yes. Go ahead.
Give me one moment. Mr. Magistrate, page 4, 8.2, case 6642. Case 6642, property owner, Lakeshore Mobile Home Park, LLC, site address 2701 South Park Road, Pembroke Park, Florida, 33009. A notice of violation was issued on 1/26/2022, sent out regular mail on 1/26/2022. Notice of formal hearing was sent out on 3/23/2022 and certified regular mail on 3/23/2022. There's a vast list of violations. Would you prefer me to list off the violations or the sections?
Just the violations, and the statutes will speak for themselves so that the owner understands. I think that might be.
Okay, I'll probably state the notes, seeing as that's more plain English.
Great.
Okay, Mr. Magistrate. So I cited Lakeshore Mobile Home Park, and they're still in violation for bulk trash all throughout the mobile home community. There's a large number of combustible materials that are being unlawfully stored throughout this mobile home park in the common areas.
Ma'am, I have a question. There are just like 22 violations here. Do you have a copy of that?
Of this that Eric sent me, yes.
Okay, if you've got you have a copy of all those violations?
I do. He
All right.
personally brought it to the office.
Okay, all right, go ahead.
And
Quick.
Mr. Magistrate, just for your information, the reason I'm citing the mobile home park is because a lot of the additions and stuff of that nature, it's because it's not so much on the mobile home itself, it has now gone onto the
Yes.
common area.
Good, it's legitimate to do that.
Yes,
because
I just wanted to make sure that you understood.
Yes, absolutely.
Okay,
yes.
so continuing, there is trash and debris all throughout the property. There are an extensive number of mobile homes inside the park that have had various types of work done without permits issued. There are numerous mobile homes that have limited or no means of egress to the back of the property. This is, in my opinion, a health and safety concern and a public works issue,
Yes.
because if there is a pipe that bursts, they do not have means back there. There are several mobile homes that are illegally housing and storing livestock. There is fecal matter from wildlife all throughout the roadway and driveways of this mobile home park. There are mobile homes that are housing aggressive dogs. This poses a health and safety concern to the community. There are several dogs freely roaming the mobile home park without owners observing them. The entire mobile home park is filled with overgrown trees and shrubbery that requires immediate trimming. There is an extensive number of mobile homes that have parking areas that are in disrepair and deteriorated states. There are several mobile homes with canopies deployed over their driveways without a permit. There are numerous mobile homes inside this park that have driveways that need to be pressure washed. There are several mobile homes with sheds that have been built and or installed without a permit. There are numerous abandoned vehicles that are broken down, have no tags, have expired tags, and present a danger to the community. The reason I say they present is because there are some vehicles with broken windows. This gives access for children to get in there and or other types of illicit, activities. Give me 1 second. Okay. There are several mobile homes that are unlawfully storing various items on, near, or blocking access to the electrical panel/meter. There are bare spots all throughout this complex and throughout several mobile homes. There are open, abandoned mobile homes that present a health and safety concern to the community. There are several trip hazards, broken materials, and unsecured materials throughout the mobile home. There is an insufficient amount of lighting inside this mobile home park. There are vehicles parking on the street blocking proper access to the streets. There are several broken fences throughout this mobile home park that require repair or replacement. And that concludes the violations. Give me 1 second. All right, Mr. Magistrate, I am recommending 90 days because this is a repeat violator of the third offense for Section 5105. My recommendation is $500 a day per this violation. As for all of the other ones, I recommend $250 a day per violation. Also assigned to that is an admin fee of $100. This concludes my testimony.
All right, so within how many days of the notice of violation, January 26, 2022?
Can you say that again, Mr. Magistrate?
The order says that the $500 a day would be within how many days of the notice of violation? Usually it's like within 10 days, within 5 days.
Bear with me for one moment, Mr. Treasurer. I'm going to go through the NOV real quick. Okay, from the original NOV issued on 1/26/2022, I gave 31 days to come into compliance for.
Okay,
So instead of 31, to make it easy, let's just go with 30 if that's acceptable.
That's good. Okay, so within 30 days of the notice of violation, that's the $500 per day, right? Great. And then the other one, your recommendation, within how many days? And it would be 90 days, you said?
Yes, for all of the other ones, I would recommend 90 days to come into compliance. I believe that is fair.
Okay, yes, ma'am. All right. Go ahead.
Hello, my name is Jenny Sanchez. I'm a new property manager at Lakeshore. Hello, Jocelyn. Hello, Eric. Hello, Mr. Magistrate.
Hi, how are you?
So, I'm asking that you guys acknowledge the statute 723023, where any violation should be the responsibility of the mobile homeowner, not the mobile park.
Yeah, I understand what the statute says, but if there's overflow and it becomes into the common areas, then it becomes a park issue rather than a owner issue. Now, I'm well familiar with that statute and how it states that if the mobile home owner violates, that it's the violation of the mobile home owner, but it becomes a common area violation, then it flows into being part of the responsibility of the mobile home park. So there is a separation. The statute also, really, when I've read it, can be argued to still include to join the park owner in some instances. I'll give you for the vanilla type of common issue would be if a mobile home owner adds a room, okay? That would, in all probability, be not a park issue. On the other hand, where the stuff flows over into the common area, it becomes an issue for the park owner.
Okay.
So, I mean, that's my notion of it. So,
I just started January
Yes.
with this new park. I have been recommending to a lot of the residents that they that they start the Amnesty Program because a lot of the violations are old. I have been
Right.
issuing violations for everything.
That's wise, because this has been going on for a long time. You know, it's common knowledge. Go ahead.
Can I ask for an extension? I don't think 90 days would be enough to really like tackle a lot of these things on the list. Can I get 120 days?
Well, what I'm inclined to do, unless the city agrees, is to give you the 90 days. But if you need more time and progress has been made, you need to file a motion for extension of time. And in all probability, as long as work is being done, there's progress, I think the city will not object to that. That will be up to the code officer. But the staff is excellent. They work with the owners, with the park owners, with the property owners, but you're going to need to show reasonable progress.
Okay. Now, when you say show progress, I need to like take pictures of everything because there has been a lot of progress since I've started. So
You need to do is cure what's going on. That's what I mean by progress, not just photos. Progress, you know, to show that, and photos that can be helpful too.
Okay.
And very easily the code officers can go on the property. Pembroke Park is a rather tiny area geographically. They're busy, but they'll make time to confirm that there's been progress being made. With like a bunch of what I heard cars being there. I mean, cars that need to be removed, and the stuff has become, it almost sounds like some of it is becoming a nuisance. I'm using that word loosely. So,
Yes, the abundance of abandoned vehicles and the ones that are parking on the road. Back to what she was asking before. Yeah, so as you start curing the violations, contact me. That way I can come out, because that's the best way to show progress. You have me come out there. We have a checklist. We go over all the violations, and like the magistrate recommended, I have no objections to the 90 days and then you requesting for an extension, because I do know you want to correct this, and I do know this is a monumental task, and you did just get started. So I am here to help. So I have no objections to what the magistrate has put forth and recommended.
right, so they'll work with you, but don't wait until the 89th day and start.
I know.
You know, okay, I say that facetiously.
No,
It
I
should be
know,
pretty
I know.
obvious what I'm talking about, okay? I mean, that statute is interesting. It's the first, 720 is the first one that carves out an exception to strict liability for the property owner. It used to be across the board, but still, park owners can't just look the other way and blink and say, well, I'm not going to do anything, because this has become a park issue as well. It's not just whoever is causing this, it's still a park issue, okay? It becomes that, whether you like it or not. You know, that's the good and the bad with being a landlord and an owner, so.
Okay. I understand.
Okay, that's right. All right, I'm going to find there's substantial competent evidence in accordance with what the code officer has said. I'm not going to repeat all this, or it'll take me another 30 minutes.
Understood.
At least. I'll incorporate it. And 90 days of today to comply with all the ordinances that you mentioned, all code provisions. Within 30 days of notice of violation, the $500 per day, which is within 30 days of January 26, 2022. That's for 5-105, and you'll take it from there, all right?
So the 90 days will start as of January, not like tomorrow?
The 90 days will start from today for every one of these violations, with the exception of 5-105.
Okay.
Because 5-105 is the one that has multiple offenses on it.
What were the cases relating to the repeat?
Okay. The case numbers the case numbers and for the final orders that were previously entered is case number 4634. Sorry, this was a, case number 4634, this is for a lien. Then for final order that was entered, previously, case number 4933. And therefore, based on what I just previously stated, that is why this is deemed as a repeat violator.
And now when you say the lien, I'm sorry, the 4634, that's on the homeowner. That's the mobile homeowner, not us.
All right, bear with me for just one moment.
Yeah, of course.
For case number 4634, in regards to the lien order, it was against Lakeshore Mobile Home Park LLC. And then for the final order, for case number 4933, that was also against Lakeshore Mobile Home Park LLC.
Okay.
Would you like a copy of them?
I would, please.
Mr. Magistrate, that concludes my testimony.
Great, okay. As I said, I already made my ruling, the substantial competent evidence, and order to that effect.
Okay.
Okay?
All right,
Good
thank
luck
you.
to you. Take care of it.
Thank
Thank
you.
you. Okay, good luck. Good luck. Thank you.
Next case is on page 2, section 7.4, case 5416. Chief Code Enforcement Officer Jocelyn Ramirez, case 5416. Property owner Holiday Hallandale MHC LLC. Tenant Raquel Delgado. Site address 3140 West Hallandale Beach Boulevard, Pembroke, Florida. Unit 911.
This was, would you say 7.2 or no?
7.4 on page 2.
There you go, 7.4. Got it. Thank you.
All right. The notice of violation was sent out by regular mail on November 2nd, 2020. And notice of formal hearing with a copy of the notice of violation was sent out by certified mail on March 25th, 22, and posted to the property on April 5th, 22. The violations were for vinyl siding applied to mobile home without a permit, multiple additions added to the mobile home without a permit, electrical on exterior, roof over and wooden deck, a glass door, and a shed were all done without a permit. And at this current time, there is not a permit in the system. So my recommendation, since this has been ongoing since October 2020, is to give the property owner 30 days to comply, if not $100 per diem and $100 admin fee.
Yes, your names, please.
Good afternoon.
Loud to your.
Good afternoon.
Yeah.
My name is Guillen Perez. He's my mother, Raquel Delgado. She live alone in.
Okay, put it closer. Stretch it to your.
I think he's very tall.
Yeah.
Hello?
There you go.
Thank you. She lived there since about 15 years, and what happened was she had been trying to make her house better looking for Christmas. He hired somebody to start installing the siding binders, and then the officer arrived and found that this had been doing without permit. In that moment, my mother realized that was wrong. So the thing was there is some stuff more was adding to the problem, and all that thing have been there for a long time ago. We tried to work on it, and we come to the city asking for how we can solve the problem, and they say we need to find an architect. In that time, since that time, I have been trying to find an architect, and it's very hard to find someone to fix the thing. But we work on what we could. We removed the shed, we removed the electricals, that most of them was like station cords for lighting outside. I talked with a person here in the city, and he told me I can forget about the roof over wooden decks, and I wish to know how can I fix the thing about the vinyl siding. I don't know if I can.
Okay, sir, look, these are violations. I'm just trying to move this thing along. The city's willing to give you 30 days to get it complied with, all right? And you're just going to need to do the best you can to do that. Whether it was there before your mom owned the property or not is irrelevant in Florida, all right? Florida law says if you buy property with violations, you assume there's violations as well, all right? So, you know, do you need more than 30 days to comply? I mean, you speak up, okay? I mean, you know, so tell me.
Okay. She lives alone in that place. I have my own house with my own family. I'm trying to help her the most I can. And
isn't this going to require a permit? Yeah.
Right. This is required. So you said that your mother inherited all these problems, right?
Say it again,
She purchased the home with the violations.
Yeah. One of the violations said there are some additions. I don't know where are the additions.
Okay, you have a single wide trailer. That means it's rectangular, right? So anything that it's outside of that rectangular single wide trailer is added onto that trailer. Okay?
Yeah, but for example, in that picture,
So,
where is the addition?
so stay there.
No, this is no.
Sí, ese sí es.
Ah, sí, ese es el frente. No.
She's saying it was there, but she purchased it that way. That means that she inherited the problem. So what your mother can do, as I mentioned earlier, is she probably qualifies for the Amnesty Program, where if she inherited those problems, the town will help her on behalf of the program to obtain an engineer and get the plans to certify all those additions that were added. But she has to apply for that program. Has she attempted to do so? For the amnesty? Not sure?
The thing is, it's hard for me to believe there are additions because most of the trailer over there have that part. One.
Yes,
one
we
by
have
side.
we have a lot of people in Holiday Mobile Home that have the same issues.
And it's over the concrete in the bottom. So as I can see, the amount of the money that she's gonna need to pay exceeds the value of the property.
Well, the Amnesty Program helps her pay for an engineer to get plans to certify everything that's there. So she would just need her title, the utility bill, and her driver's license to apply for the program.
Yeah, but probably that's gonna take more than 30 days.
Well, if you get approved, that means that they will help you with the code enforcement proceedings. But you have to apply. As soon as you apply and you get approved, you got to let me know.
Okay, but that can solve for example, that gonna solve any of the problem we have here. Okay, I can
If you qualify for the program, yes.
So what should I do?
Get a title, her title, driver's license, and a utility bill that matches the address, lot 911, and then you can apply for the Amnesty Program.
I think this is the best we can do.
Okay? Just call me as soon as you get approved.
Give them 60 days, or should 30 days be enough?
Okay, I'll change to 60 days.
That's, going to give you 60 days to do this. It shouldn't take 60 days to get approved, but the rest is on you. If you'll help your mom out. That's all. She can get into the program. They apparently will help her, and that's the important thing. All right. Based on the testimony, the evidence of a compliance officer, there's substantial competent evidence to support the city's position. They'll have 60 days in which to comply, or $100 a day thereafter. So you need to start moving on this. If there are forms, fill them out. All right?
And can I have your name one more time?
Guyen Perez, Guyen
And?
Perez.
Yes. And you're her son.
Ma'am, you have a good son there. He's going to help you. Understand? Well, tell her what I said, okay? Sure.
Un segundo les doy la copia.
Next case is on page 6, section 10.4. Case 4848. Chief Code Officer Jocelyn Ramirez, case 4848, property owner, Garden Property 786 Inc., tenant Family Grocery, site address 2950 Southwest 32nd Avenue, Pembroke Park, Florida. This matter is here to abate a fine. Notice of hearing to abate fine was sent out certified mail March 23rd, 22, and posted to the property on April 5th, 2022. The total amount to be abated is $29,100. It is the town's motion to abate it to 15% of the per diem fine, which is $4,350. In addition to that is the recording fee of $68.50 and $100 administration fee, which is a total of $4,518.50.
You're up. Go ahead. That's okay.
I'm here on with the owner of the building. We're Savvy LLC, GC company. We
The
appreciate
microphone, please.
we appreciate the offer for the 15%, but the owner didn't. The violation was regarding signs.
Yes.
And the tenant actually, without authorization from the owner, put these signs, and you guys send certified mail notice of violation to the address on the Sunbez, which was an old address that was updated. So he did not receive, I apologize, he did not receive, so sorry, he did not receive this notice till later on. He did hire a contractor, but because of COVID, they didn't follow up. They had actually the permit, but nobody followed up with it. And then they hired us, and then from the time that we started to the finish, in a timely manner, you see that we did 3 permits back-to-back, passed, finalized, and, he had, his dad was sick and through COVID, he had a lot of financial hardship to pay us even. So we did an installment payment with him to be able to do this work for him. So we were looking to like a little bit more discount if possible, just because of, all the costs that he had to carry. Although we understand that his responsibility as an owner, but the tenant acted not on his behalf, and he's carrying all the fees and everything else.
What number do you have in mind? Right now, we're at
2,500.
4518.
2,500, just because there are other violations. The tenant did more than, this is one of the cases, as Joseline knows, and I closed all of these violations. I pulled all the permits necessary. We have only one thing pending. So this is like one slice of a pie. Like, there's a lot of costs, a lot of other violations that I'm taking care of. And
Is there a history of this property, if you happen to know? If you don't know off the top of your
Yes,
head.
there is a history on the property of non-compliance, but it did go, let me see what the CPA says.
And
what year did you purchase the property? And can you state your name for the record?
My name is Adil Sajwani, almost 10 years ago.
And actually, you guys weren't here earlier, so you haven't been sworn in, correct?
No.
So that's a problem.
We swear you in, okay.
raise your right hand and solemnly swear to tell the truth, the whole truth, nothing but the truth, please. If you could affirm.
Yes.
Great. Okay, go ahead.
Okay, so you said you purchased the property when?
Almost 10 years ago.
10 years ago. Okay, so that was August 25th, 2010?
I can remember properly. Almost more than 10, 12 like this.
Okay. So I know that, Manar, you said that the notice was sent to Sunbiz. No, it has been sent to every address listed on Broward County Property Appraiser and Sunbiz.
Yeah.
So that's proper notice was done for everything. Yeah, but to answer your question, there is a history of violations on the property. It could be possible, as they said, that the tenant are doing things without his consent, but it is ultimately the property's owner's responsibility to be on top of that.
Yeah, and we have, you know, I'm not going to argue that.
Yeah, no,
And he's aware of it, but the minute he was aware of it, he hired us and,
Right,
you know, he
okay.
paid us all
You
the
took
fees
care-
to comply.
So is the tenant still in the property, the same one that caused the problems?
No, another tenant.
Have another tenant?
Yeah. And they left without paying rent because of COVID and everything, so.
Okay, what I'm gonna do is, so that we can move this thing along, and you've been waiting here for longer than you'd like, I'm sure, but anyway, I'm gonna go with 3,500 even, all right? To give you a break, payable within 30 days.
Can you give a little more time, please?
How much days? How much time?
Like 60 days, is that possible?
60? Okay.
Okay, 60 days, you said 60 days?
Yes.
If it isn't fully paid within the 60 days, it reverts back to $29,100. This is a no-brainer,
Yeah,
okay?
absolutely. We
Really?
appreciate it. Thank you so much.
Okay,
Thank you,
so
Joseline.
that's okay. So get 3,500, and you need to thank the city too, because they have authority to help out, and they do, and I try to help out as
Of
well,
course,
but you
you
know,
guys do.
but they get all the credit.
Yeah, we appreciate that.
Yeah.
Aside from this case, you have another one that came into compliance, right?
Yes.
You have to, if you want an abatement, you have to write the formal letter for
Yes,
that one.
we will. But if you could confirm which one for me, because I have, you know.
What? What do you need?
Could confirm the case number.
I don't know it. I don't know it at the top of my head.
So could
I
you
can
email me?
message you later.
Yes, please, thank you. We appreciate it.
Please hold on, I will give you a copy. Okay.
By accident. Thank you very much. Sure, it's a
Manar, can you please sign in? You didn't sign in the sheet. Okay, Mr. Magistrate, we're going to go in the order of the agenda.
Oh, yeah, right. No more. Let's see. Yeah.
Oh, no, that's our staff member.
Okay, all right. Go ahead. Let's run through them, you know.
All right. Chief Code Officer Jocelyn Ramirez, case 4959A. Property owner Steve's Transmission of Broward County, Inc., SKOPP, Stephen D. Site address that the violation occurred was Southwest 38th Avenue. That's a town right-of-way, town's swale. Steve's Transmission is located on 3803 Hallandale Beach Boulevard, Hollywood, Florida. A notice of violation with a copy of the notice of formal hearing was sent by certified mail on March 8th, 2022, and hand delivered to the property on March 14th, 2022. The violations were for storing multiple business vehicles on town of Pembroke Park swale. Parking is prohibited at all times. All vehicles were to be removed within 5 days of the notice. Any of the vehicles that remain will be towed at the owner's expense. The property owner of Steve's Transmission did in fact remove all those vehicles at the time of within the time of the notice of violation time frame. But I want to adjudicate this case as to prevent it from happening again.
Right, okay. Okay, so what's your notion, like within how many days is the order and that the code shall comply with held on?
I put within 5 days.
5 days, within 5. What, 250 per day or 100, you tell me?
Well, as I mentioned, they already complied.
Okay,
I just want to adjudicate the case.
okay, all right.
And if we need to change something in the order, just let
Yeah.
me know and we'll get that corrected.
Have to do that, hold on.
I believe we just are assessing the $100 administration fee.
I can initial all this, what I'll say, order the special magistrate enters that there's been, shall comply within 5 days of the date of the formal hearing held on 20th of April 2022. Respondent has complied within a time specified, but there's a $100 administrative fee. Do you want to change this around, type it over again, or you want me to just initial it?
Yeah, she'll type it off.
Okay, all right. All right, I'll go ahead and find that there's substantial competent evidence. Let me work on this a little bit as we go through this, and then you'll type it over.
Yeah.
Okay, very good. You can call the next case.
Okay.
Great.
Next case is Mr. Magistrate, I forgot to mention that case 5397 did ask for me to postpone this till the next meeting.
Okay, all right. No big deal. All right, so that'll be postponed.
To the May 18th, 22nd meeting.
Repeat the case number, please. Just.
Huh?
Can you repeat, please, the case
That's
number?
case 5397. And I just want to state for the record that for case 4959A, the property owner was not present. All right, next case is 5396, that's on page 1, 7.3. Okay, Chief Code Officer Jocelyn Ramirez, case 5396, property owner Pembroke Place 2, HOA Inc., care of Phoenix Management Services Inc., site address Southwest 38th Street, Pembroke Park. Address of HOA is 4800 North State Road, 7 Suite 105, Lauderdale Lakes, Florida. A notice of violation was sent out by regular mail on October 20, 2020. A notice of formal hearing with a copy of the notice of violation was sent out by certified mail March 25th, 22, and posted to the property on April 5th, 22. The violations were for exterior maintenance of common areas and driveway required maintenance, i.e. pressure wash treatment paint. That has not been complied with. The next item was repair of gate and key access device. Obtain permit inspections for repair. That actually has been partially repaired as of April 5th, 22. Exterior of roof requires maintenance, i.e. wash treatment paint. The roof has been washed. It looks better now, but it still requires improvement. Exterior maintenance of fence wall and monument sign, i.e. pressure wash, treatment, and paint. That still exists. Dead vegetation, remove dead hedges and replant. They removed the dead hedges, but did not replant new ones. Exterior maintenance of wooden fence, i.e. pressure wash and straighten. Maintenance is still required for the fence as of April 5th, 22. So my recommendation is to give them 30 days to comply with the items that are still pending, if not $100 per diem with a $100 admin fee.
30 days, and how much per
$100 per diem.
per day? Okay, and $100 administrative fee. Okay, all right. In this case, based on the testimony of the evidence of the compliance officer, there's substantial and competent evidence to support the city's position. Respondent will have 30 days in which to comply, or $100 per day thereafter. Don't worry about it, because we're going to be running back and forth. So next, we were talking about the next case here that was.
That was case 5396.
5396.
Okay, I'm sorry.
Okay, no, it's all right. So thank you.
Next case is on page 2, case 5525. Chief Code Officer Jocelyn Ramirez, case 5525, property owner Andre Marcoux, site address 2511 Southwest 48th Terrace, Pembroke Park, Florida. A notice of violation was given by regular mail March 20. I'm sorry, I think I had the wrong day. By regular mail on February 4th, 2021. A notice of formal hearing with a copy of the notice of violation was sent out by certified mail on March 23rd, 22, and posted to the property on April 5th, 2022. The violations were for an addition that was built without permit on the left side of the property, a shed, enclosed porch, installation of door on the back end of the home, all done without permit. At this current time, the owner has only obtained a permit for an addition and is currently in progress. Therefore, at this time, I'm going to recommend 30 days to comply with all the violations, if not $100 per diem with a $100 admin fee.
Based on the testimony of the evidence of compliance officer, there's substantial competent evidence to support the city's position. Give them 30 days in which to comply, or $100 per day thereafter.
And let the record reflect that the property owner is not present. Next page is page 3, and it's section 7.12, case 6832. Chief Code Officer Jocelyn Ramirez, case 6832, property owner Drew Boy Inc., site address West Hallandale Beach Boulevard, Pembroke Park. A notice of violation was sent out by certified mail March 23rd, 22. A notice of formal hearing was sent out by certified mail March 23, 22, and posted to the property on April 5th, 22. The violations were for storing abandoned vehicles on property. Parking lot has multiple cracks and shrubbery. Wooden fence is at its life limit. Wooden fence has to be replaced with new wood, obtain permanent inspections. Trees require trimming. And an RV park. An RV is parked in the commercial area is prohibited. They have to remove the RV from the property. This has been removed. And then concrete wall fence has rust stains. Remove rust stains from concrete wall. I have been in contact with the property owner. He did mention that it was difficult for him to make it today, but he did agree with 45 days to comply. If not, $150 per diem with a $100 admin fee.
Based on the testimony, the evidence of co-compliance officer, there's substantial competent evidence to support the city's position. He'll be given 45 days in which to comply, or $150 per day thereafter.
Okay, the next case is 6833. Same owner. Chief Code Officer Jocelyn Ramirez, case 6833, property owner Drew Boy Inc., site address 5590 West Hallandale Beach Boulevard. Notice of violation and a notice of formal hearing was sent out by certified mail on March 23rd, 22, and posted to the property on April 5th, 22. The violations were for paved and restriped parking lot without a permit, roof exterior requires maintenance, storing of abandoned vehicles on property. This has been complied with. Abandoned vehicles have been removed. Prohibited outdoor storage. Trees require trimming. Exterior building requires maintenance. Remove dirt buildup from exterior walls and common areas. Pressure wash and paint. The property building has been painted. So at this time, I'm recommending 45 days to comply with the rest of the items, if not $150 per diem with a $100 admin fee. And as I said, the property owner does have difficulty coming to this hearing today, but did agree to the 45 days.
From the testimony, the evidence of compliance officer, I'm going to find there's substantial competent evidence to support the city's position. They'll have 45 days to comply. or else it'll be $150 per day thereafter if they do not comply. Of course, as always, the $100 administrative fee. I assume, I mean, I would charge, even if I don't say it, I'm charging it. It's in the orders anyway, it should be charged. Okay.
Okay.
Thank you.
All right, next case is 6874. That's on section 7.14. Chief Code Officer Jocelyn Ramirez, case 6874. Property owner Medina Land Holdings 12 LLC. Site address 2570 South Park Road, Pembroke, Florida. A notice of violation and a notice of formal hearing was sent out by certified mail March 25th, 22, and posted to the property on April 5th, 22. This is a repeat violation. MTX Group 1 LLC tenant is storing construction material outside, and outdoor storage is prohibited. All construction materials must be removed immediately. Silt mesh is not allowed. Please refer to section 28-33 for fence standards. Remove silt from fence. At this current time, the property owner has not complied, and for section 12-48, since it's a repeat violation, I would like to recommend to assess a $500 per diem fine from the date of the notice of violation, which was March 24th, 22, and I gave 5 days to comply.
And the other one, 28333, within how many days of today?
I would like to say 1, but I'm going to say 5 and a $250 per diem.
Okay, gotcha. Okay, based on the testimony of the compliance officer, there's substantial competent evidence to support the city's position. They'll be given 5 days to comply for the violation 28-333 or $250 per day, and for the repeat violation, it's $500 per diem. Within 5 days of March 24th, 2020. Thank you.
Okay, next case is 6905. Chief Code Officer Jocelyn Ramirez, case 6905, property owner Gerald Anderson. Let the record reflect that the property owner is not here. Site address is 1708 Southwest 31st Avenue, Pembroke Park, Florida. A notice of violation and a notice of formal hearing was sent out by certified mail on April 6, 2022, and posted to the property on April 7, 2022. The violations were for A and B, recycling has an accumulation of scrap metals and hazard materials causing spillovers and obstruction on town's right-of-way. Property owners in violation of the certificate of occupancy. Property owners must clear all scrap metal, hazardous materials, and other materials from town's right-of-way immediately. Business owner is using town's row and public parking area to unload and reload scrap metals and materials. Business owner is only allowed to operate within 1708 Southwest 31st Avenue property lines. Prohibited use of public parking area. Do not use public parking area to unload for business use. Property owner is using public parking to park his forklift for business use. Remove forklift from public parking area. Town's road has to be clear of any or all materials. Owner will need to clean up property within 5 days, or areas will be cleaned up by the Public Works Department at owner's expense. upon the failure of the property owner or owners to remove the conditions creating the nuisance as aforesaid within the designated time period, the town shall cause such condition to be removed and shall assess the owner or owners of the properties for such services in the amount equal to the cost incurred by the town in the removal and disposal of the garbage, trash, rubbish, or other debris, which cost shall include but not limited to disposal fees, removal expenses including both labor and vehicular expenses, and an administrative fee in the amount of $250. And then last item is the graffiti on the north wall. Remove all graffiti. Since this is a repeat violator, referencing to case that were adjudicated is case 6426, case 5523, and case 4400. The sections that are considered repeat violations are sections 12, 12-42, 12-46, 12-48, which I'm recommending a per diem fine of $500. And we gave the property owner 5 days of the date of the notice of violation.
Right, which was April 6th. All right, and then there's...
Yes, April 6, 22.
Great. Go ahead, sorry.
And then sections 22-85, 28-215, that's a per diem of $500 from the date of the notice of violation, which is April 6, 22.
That also within 5 days?
Yes.
And the one, the 5-207, is that?
That's the same. 5-207, recommendation of $500 per diem.
Everything.
From the date of the notice of violation, April 6, 2022.
Great. Okay, that's for all these three. All right. All right, I'm going to go ahead and, based on the testimony of the compliance officer, there's substantial competent evidence to support the city's position in every one of these violations, with all the code violations, given within 5 days of the date of notice of violation issued on April 6, 2022. It'll be $500 per diem for each of the violations occur beyond the compliance date for each of these. It's $500 per diem. Thank
And
you.
Mr. Magistrate, I also like to add that the admin fee based on our ordinance, town ordinance, is $250.
That's for these. Great. It's in the order here. Now,
Yes.
Also, the administrative fee here is going to be $250, payable within 30 days. Great.
And also, I included a clause, if you can read it for the record.
Yes. About the cleanup?
Yes.
Okay, the town of Pembroke Park will clean up town's right-of-way and install chain link fence, i.e. delineators, to remediate obstruction of town's right-of-way at the property owner's expense not to exceed $10,000. Okay, and that'll be part of this order as well. I think that there's a word used for that when you can do that. It might actually be abatement, not the same abatement.
Yeah, abatement notices.
Exactly. So that's permitted as well. So that in this order. Thank you. Very
Thank you.
good.
All right, I have one more case. That's on page 6, section 10.7. Chief Code Officer Jocelyn Ramirez, case 6168. Property owner Amita Development LLC, site address 2350 Southwest 30th Avenue, Pembroke Park, Florida. This matter is here today for an abatement of the fine. Notice of hearing to abate fine was sent out by certified mail on April 6, 22, and posted to the property on April 7, 22. The total amount to be abated is $31,100. It is the town's motion to reduce the amount of the per diem fine to 15%. That's $4,650 plus the administration fee of $100. That's $4,750. And the owner and I have been in contact. He did agree to that amount, and therefore he's not here today.
Okay, so it's $47.50.
But yeah, I'm sorry.
No, you
And
go
then
ahead,
he
finish.
did request if he can pay within 120 days.
Okay, is that acceptable?
Yes.
All right. Fair enough. So it's going to be abated to $4,750, payable within 120 days. Thank you very much.
And that concludes all my cases.
I presume you're ready for another 20. No, I'm kidding.
All right.
Now it's your turn.
Yes.
Yeah.
All right. Code Officer Rich Wagon, representing the town of Pembroke Park. Page 3, section 8.1, case 6639. Case 6639, property owner identified by Mark Duquois and Linda Richon. Let the records reflect that they are not present. Site address 112 Marine Court, Pembroke Park, Florida 33009, lot 502. On 1/25/2022, notice of violation was issued, sent out regular mail 1/26/2022. Notice of formal hearing was issued on 3/23/2022. Certified mail on 3/23/2022. The property is in violation of, there was a shed that was being worked on without a permit. There are lights in the back of the property that have been removed without a permit. It is my recommendation, because I did speak with the contractor, who informed me that the tenants are now back in Canada. The contractor has gone ahead and started the process for the permit, is requesting 90 days, which I will adhere to, with a fine of $50 a day for the violations.
Very good. Right. Based on the testimony of the evidence and compliance officer, there's substantial competent evidence to support the city's position. Give them 90 days which to comply, or $50 a day thereafter.
All right. All right. Code Officer Rich Wagon, representing the town of Pembroke Park, page 4, item number 8.5, case 6717. Case 6717, property owner identified by Amita Development LLC. Let the records reflect that they are not present. Site address is 2350 Southwest 30th Avenue, Pembroke Park, Florida 33009. On 2/4/2022, a notice of violation was issued. Violation was sent out regular mail on 2/4/2022. Notice of formal hearing on 3/22/2022, and certified mail on 3/23/2022. The violation is that there is bulk trash throughout this commercial property. My recommendation is 30 days to come into compliance with a fine of $100 with an admin fee of $100.
Based on the testimony of the compliance officer, there's substantial competent evidence supports the city's position. 30 days which to comply are $100 per day, and there's always a $100 administrative fee.
All right. Code Officer Rich Wagon representing the town of Pembroke Park, page 5, item 8.6, case 6718. Case 6718. Property owner identified by Discount Auto Parts, Inc. and Advanced Auto Stores, CO, Inc., number 9479. Let the records reflect that they are not present. The site address is 3000 West Hallandale Beach Boulevard, Pembroke Park, Florida, 33009. On 2/4/2022, a notice of violation was issued, sent out regular mail on 2/5/2022. A notice of formal hearing was issued on 3/22/2022, sent out certified mail on 3/23/2022. The violations are as followed. There's bulk trash and other materials being left outside in the rear of the property, and there is graffiti on the utility box. My recommendation is 30 days with a fine of $100 with a admin fee of $100.
Based on the testimony of the compliance officer, there's substantial competent evidence to support the city's position. They'll be given 30 days in which to comply, or $100 per day thereafter.
All right. Code Officer Rich Wagon representing the town of Pembroke Park, page 5, item number 8.7, case number 6719. Property owner identified by Lakeshore Mobile Home Park, LLC, Juan Torres. Site address, 2701 South Park Road, Pembroke Park, Florida, 33009. And the unit address is 125 Lori Lane, Pembroke Park, Florida, 3309. On 2/4/2022, a notice of violation was issued, sent out regular mail on 2/4/2022. Notice of formal hearing was issued on 3/23/2022, sent out regular mail on 3/23/2022. The violations were that upon doing a ride through the area, I observed that there was interior structural work being done inside this mobile home without a permit. It is my recommendation of 30 days to come into compliance, otherwise a fine of $50 for the violations with an admin fee of $100.
Okay, based on testimony of its compliance officer, there's substantial competent evidence supports the city's position. They'll be given 30 days in which to comply, or $50 per diem, plus, of course, the administrative fee of $100.
Code Officer Rich Wagon representing the town of Pembroke Park, page 5, item number 8.8, case number 6722. Case number 6722, property owner identified by V&A Miami LLC, site address 4400 West Hallandale Beach Boulevard, Pembroke Park, Florida, 33023. A notice of violation was sent out on 2/7/2022 and regular mail. Notice of formal hearing was sent out certified mail on 3/23/2022. The violations, which they are a repeat violator, is as followed. Prohibited outdoor banner sign is being displayed at Boost Mobile. It is my recommendation that the banners be removed in 5 days with a fine, seeing as they are a repeat violator, with a fine of $500 for the violations per day, with an admin fee of $100.
5 days of the notice.
Okay. Recommendation, 5 days of the notice of violation.
Right, February 22nd.
The notice of violation was issued on 2/7/2022. Give me 1 second so I can go and find you the former violation case. Should be right. The previous final order, case number 6060.
Okay, the order here says 5 days of the date of notice of violation issued on February 22nd. Is that correct or is that not correct? No, what?
The notice of violation was issued on 2/7/2022.
He needs to correct the order for you.
Okay, no, that's okay. I'll just
So you
write
could just,
over it.
yeah, mark on it. You need to.
Oh, it's February 7th.
Yeah, except I fixed one.
On the orders, did you want the cases that are considered repeat or just on the records is fine?
Pardon me, what was that? I'm sorry.
When there's a repeat violation, do you need the previous cases on the order?
No.
Okay.
As long as you've got it of record, in the findings, you just say it's a repeat violation. And it would show up in the public records anyway if they're recorded, if not, but you have it in your file. So in this one, it's February 7th, not February 22nd.
Yeah, because the violation was issued on February 7th.
Okay, so we'll go that. I'll just write, you don't need, I'm just gonna initial it as well.
Code Officer Rich Wagon, representing the town of Pembroke Park, page 5. Item number 8.10, case 6829. Case 6829, property owner identified by Pembroke Park Parks Villa, LLC, site address 4945, Southwest 41st Street, Pembroke Park, Florida, 33023. Notice of violation was sent out certified mail on 3/22/2022. Notice of formal hearing was sent out certified mail on 3/22/2022. And an affidavit of noncompliance was issued by regular mail on 4/7/2022. I am recommending 60 days to come into compliance with a fine of $50 a day for the violations with an admin fee of $100.
Thank you. How many days on Pembroke Park Villa, 6829?
So because on 4/6/2022, they did come into compliance with quite a bit. However, there's still stuff left over because they're showing that they're trying to alleviate the issues.
Right.
I'm recommending 60 days.
Okay, 60 days this is in 6829, within 60 days, right?
Yes, case 6829.
Did you say $50 or $100?
$50.
50, okay. Got it. Okay, based on testimony you have as a compliance officer, there's substantial competent evidence supports the state's position. They'll be given 60 days in which to comply or $50 per day thereafter. Thank you. There you go.
And I have one more. All right, I'm Code Officer Rich Wagon, representing the town of Pembroke Park. On page 7, 13.1, case number 6133. This is the town's motion to vacate final order. Okay, so the reason I am requesting to vacate the final orders because due process was not given on the date of the hearing. Instead of it being 9 a.m., it stated, I believe, 3 p.m. Stated 6:30 p.m. They did show up at the wrong time, but that is an error on me.
Okay, that's all right. You look, God, with all the paperwork, it's a miracle that it's not far worse. I mean, or that's not bad at all, so don't worry about it. So you'll give them another notice, it's no big deal.
Mr. Metro, just so you know, we
all
are vacating it, but we are going to continue it.
Okay, all right. Have the order, okay. That's all right, that's all right.
He doesn't have the order drafted, so we're gonna have to draft one.
Okay, do you want to try, and you'll send it to me, you'll scan it to me, and I'll sign
Well,
it.
if
Do it now?
it's, yeah, if you can stay for a little bit.
Oh, yeah, I'll
we'll-
stay. No, it's okay. That way we can get it done. I agree. That
Yeah.
way you can move it out. This is
Yeah, because we'd like to send them out right away.
great.
Does that conclude your case then?
Perfect.
This
Okay.
concludes my cases and my testimony.
Sure.
Mr. Magistrate, I have a few cases here that there's clerical errors.
Okay.
So how would you like me to proceed with these
You
cases?
go ahead, and there'll be amended orders that'll have to be signed with the clerical errors or not?
That's what I wanted to ask you.
Okay. We have the orders where there's clerical errors, and I guess how many are there?
Seven. There's seven.
7. Okay. Clerical, like a date was wrong, or sometimes it might be 2022 when it should be 2021.
Sections. The sections.
Sections.
Some of
Okay.
The sections.
If has anybody complained about the no, and there have been final orders entered.
Right.
Okay. If somebody complains, you have to send them again and go through that.
Yeah, we'll send them again.
Okay.
But the date still stands, correct?
Okay, yeah, the date still says, it would just be then an amended order or a corrected order, because if we call it that, you're liable to think that it's a new time that begins. That's not what the intent is. I don't know how, have any of them begun to comply, or do you know, is it too soon?
The majority of them, no.
I guess in an abundance of caution, probably should make the changes with the orders. I'll sign them and we'll call them amended orders. Or we can just send them out without changing them to amended, keep it as it is, as whatever the title is, like order rather than amended order, and it'll just have the correct statute number, the code number, and it'll be the same with the same times with everything else. So,
Yeah, I agree.
okay, why don't we do that? That would probably be, give me your notion. Should we call it, I like to listen, should we call it an amended order, or should we just call it a corrected order?
I would say corrected.
Corrected, yeah, it's not really an amendment. Let's go with the corrected order, and if it's not typed on there, it can be handwritten on there. I do that all the time in other cases. If you want to type it on there, corrected order, that's fine, but keep the same dates, obviously, and that way it'll be sent to them, you know, that's life, that's all. It's, you know, with all these numbers, I don't know how you all do it. You do splendidly, really, to get this stuff done, so.
Okay.
Afternoon
Do I
session.
have to state them for the record, the ones that we're correcting?
Yeah, why don't you go ahead and do that, and then we'll go ahead and quickly take care of that.
Okay. So the first case will be case 6426, and we're correcting the ordinance section. Do you need me to state the sections for the record?
Yeah, just the corrected one.
Okay.
That's all.
So the errors were 5-103A, 5-207. We're correcting it to match the notice of violation, which is section 12-41, 12-48, 22-85A, and 28-215. Leslie, can you help me?
Yes, yes.
So I'm going to hand you the orders as we're correcting them, and so you can hand it to the magistrate.
Right. Does it say corrected on there already, or
No.
I'll handwrite it on there. It's
Yeah.
no big deal, you know, believe me.
You could just go from the front, because I'm going to give
Yeah.
I'm going to give you more.
You've lost enough weight. You don't need to run any extra inches like I do. Now, I need to run extra, so. This is the corrected one right here. Okay.
Yeah.
Right, you put the times in here within 5 days. Great, okay. We don't know what'll happen, but in all probability, when they see this, they'll come back for an abatement when they finally comply.
Yeah.
It can all be sorted
5,
out.
Officer Reyes.
Oh, take care. Thanks for your help. Look, I saw you yawning a little bit there. I don't blame you. I know. Thanks. Take care.
Te lo vamos a mandar. Okay, actually I have less cases than what I mentioned.
Okay, that's all right. You know,
Only 4.
right.
Mary no paró el video, ¿verdad? Revisa. Todo está corriendo.
Está live.
Okay. All right. Next case is 5558. Nasli? Fix the sections. So here we're just correcting the title from final order. It's an amended final order. And the sections, we're adding section 5-87. That was the only section that was missing. So we're correcting it to match the notice of violation.
Great, okay.
Escribiste eso mal. But, y tenías que arreglar los dos. There's a final order here, the original final order, but it was signed by the other magistrate, Raphael. So I believe I have to give it to him, right?
Was it for a final hearing?
It was a final order, yeah. But this is I think the most important one is this one.
Yeah.
Because that was the last, that was adjudicated.
Okay, that was the one, all right, this was. Let me just take a quick. You might want to give it to him, although, you know, I've seen it signed by another magistrate. If he heard it, he probably should sign it.
That's that one? Okay. All right, the next case is 5554. Pero me parecen igual. So for case 554, the ordinance that was missing is 5-87, but one second. So I think what was going on, because these are cases from Officer Teresa Malcolm.
Yes, okay.
And so like the section 5-87, it says it shall be unlawful for any person, firm, corporation, or association to operate or undertake dredging in the town without first obtaining a permit. So I believe she removed that section from the final order because they were not dredging. So how do you want to proceed? Is it fine to remove that section from the final order?
Were they dredging?
No, they were not.
Okay, so if they weren't dredging, then you take it out of the final order.
Yeah, so there's fine. There's no correction needed on
Okay,
this
good.
one.
If it needs to be crossed out, I can do that. I mean, if it's there inadvertently, so.
No, the correct one is fine.
Great.
Pero hay uno que dice amende. Now what needs correction is just one that says that it was amended, but that's an easy fix. We could just fix that without a signature.
Okay.
And let me see what the other one was. And again, these are Teresa's cases, Malcolm's cases, previous cases. Pero lo único. All right, so case 5604 It just seems like it was missing an ordinance, and that was section 15-152.
That'll be a corrected one or amended.
Díaz le dio. $60. And that was all. Do we have to still correct some of the orders for you?
There's just one, he's doing a motion to vacate, the order vacating, because the time was in error.
Okay. Can we adjourn the case, or do we have to wait?
We can adjourn, and I'll just wait and sign it.
Okay. All right. Because you already made your ruling for that one.
Exactly, so we'll adjourn, it's 1:40.
Okay.
Okay.
Yeah. We adjourned the case at 1:40.
Huh?
1:40.
Oh, okay.